This is going to be a discussion on Dr. Darr's latest book, Competition Law in South Asia. My name is Abbas, Moosvi, Research Fellow at PIDE. We're going to be talking about markets, and we're going to be talking about sort of the fact that mostly like neoclassical tradition within the economics stream, it seems to sort of promote this idea that competition is sort of, or it should be taken for granted. It's almost sort of inevitable with the development of markets, right? Just like free the market, free it of all kinds of interventions from the government, and competition will be inevitable, right? I don't think this is the case. There's great work that's done on this topic by Professor Anwar Sheikh, who teaches at the New School in New York. So for anyone who's interested in this, I'd highly recommend his work. I think the way to conceptualize this would be to think of it like if you were to plot competition against time, it would probably be an inverted U-shaped sort of graph where it rises and falls eventually with the development of monopolies and so on. So we're going to get into all of these details. Obviously, this is a bit of a complex problem to solve naturally for policy people in general, because you have to sort of look at the balance between the public and the private interests in terms of welfare on the one hand and profits and corporate interests on the other hand, right? So determining which domains should be intervened in and at what time they should be intervened in is an important question. Generating laws that are sort of nuanced enough to appreciate incentive structures of institutional arrangements and dynamics, also very important. The quandary of implementation, our sort of state agencies in general are sort of structured in a manner where they have generally adopted kind of perverse incentives, and they don't really or aren't able to get what they need to get done. And so that obviously has to do with internal managerial arrangements, incentives, and so on and so forth. Regulatory authorities, we'll talk about those. We'll talk about the history of competition law in Pakistan and in South Asia in general, its origins, its evolution over time, future of competition law, how Pakistan compares with other countries in the region as well as the globe. And sort of larger governance arrangements. Ultimately, state institutions are always sort of responding to the interests, sort of entrenched interests of the larger governing ruling elites. So we'll talk about those as well, and what authorities, what interests that they are sort of beholden to. I want to thank our panelists for joining us. Ms. Rahat, Kaunain, and Hassan is the former chairperson of the Competition Commission of Pakistan. She has 30 years of professional experience with 12 years in public service, and she's a distinguished lawyer. I'm sure most of you are familiar with her. And then we have Dr. Darr, who's the author of this book. She's a lecturer at the University of Manchester's, and she teaches competition law at the University of Manchester. She's a senior research fellow at the UCL Center for Law, Economics and Society, and she's an advocate of the Supreme Court of Pakistan. The structure of this conversation generally is going to be, I'm going to hand over the floor to Dr. Darr for a 40-minute sort of monologue about her book, about the salient details. And I believe she has a presentation as well. And then we'll hand over the floor to Ms. Rahat for her comments, her thoughts on the book, her analysis for 20 minutes, and then we'll move to Q&A for about 15 to 20 minutes or so. So this is going to be a bilingual discussion, so please feel free to sort of go Urdu if you'd like. I'm a bit of a burger bacha, so I'm going to talk in English, but please feel free. Okay, without further ado, Dr. Darr, please. Thank you.
So thank you very much, Abbas, for your kind introduction. And thank you to everybody who's here, especially Rahat, for taking out the time. And of course, Dr. Nadeemul Haq, who's not able to join us today, but I think for very kindly agreeing to organize this panel. So thank you very much. I have prepared a presentation. So I'm going to begin with that. I think it just becomes easier if you have something to train our eyes on. Abbas has suggested that I might be giving you a lecture on competition law, but that is not my intention at all. What I do want to share with you is the journey of writing this book, which was published in February 2023. And I had to wait till I visited Pakistan to actually present it to you. So let's begin. I just thought of a few questions for myself, which I will address in the course of this short conversation. I'll tell you what this book is about, why I think competition law is important. Why did I choose to write about it? Because this is a question that I've been asked many, many times कि आपको और कोई topic नहीं मिला, human rights पे कर लेती, women's rights पे कर लेती, जो कि पाकिस्तान में हमारे यहाँ बहुत अहम topics रहते हैं, Islamic law पे कर लेती. But there was something very attractive to me about this topic, and I will share it with you. And then the methodology. I think the reason I'm keen to talk about the methodology is because we're all researchers. हम सब एक दूसरे से इसमें, I learn from you. आप अपना भी feedback मुझे दीजिए. I'll share my methodology with you. Data कौन सा था, and what are the major findings, and what I hope the impact of this book will be. So these are just some of the questions I'd outlined for myself. So what is this book then? So basically, since 2002, all 8 South Asian countries, and this was a bit of I had to do a little bit of thinking around kaun se 8 South Asian countries humne lene. So I went for the SAARC definition, or the SAARC list rather, of 8 South Asian countries, and they've all adopted modern competition laws. So अगर आप इस map पे देखें, 2002 में India adopted a legislation, 2003 Sri Lanka adopted a Consumers and Market Act, 2007 में Nepal, इनके मुझे नाम इस वक्त भूल गए, सारे लंबे लंबे नाम हैं इन सब acts के, but they all enacted legislation. 2007 ही में Pakistan, so Nepal in fact adopted it in February, we adopted our law in October, and 2012 Bangladesh. And 2020, so very recently, Maldives, a tiny island state, has also adopted the law. And then even the little tiny country of Bhutan, just north of India, has 2 competition policies. It's went through 2 cycles. It had one in 2014 and then another one in, sorry, can somebody manage the Zoom room? Because I think the people trying to enter. So I don't want to. Okay, thank you. Bhutan had a policy in 2014 and 2020. And then the funniest I find is Afghanistan, jiske masail hum sabko pata hai. I think in this audience, I don't need to talk about Afghanistan's issues. And even they have a draft competition law. So it really makes you wonder, why is this law so important that all these countries, which are beset with other economic issues, are also adopting these laws? What I discovered, what this book discovers rather, and I talk about, there was a lot of external reasons for why the countries adopt these laws. Mostly there was a WTO membership, which played a very important role. Jaise hi aap WTO membership aapne li, most of these countries joined the WTO in 1995, just as WTO was formed. तो उनको उस वक्त एक तहरीक चल रही थी कि international competition law होना चाहिए. So I think some countries like India were very, very proactive, and they said, इससे पहले कि कोई हमें बताए क्या competition law होना चाहिए, we'll get into it and we'll start thinking about what we should do. And I think there was वो फिर नहीं हुआ, that there was no international competition law, but the momentum had set in place. And then every country in the region, as you've seen, went and adopted some kind of a competition, either a legislation or a policy, or in case of Afghanistan, they had a draft act. 2011 se unke paas hai, but after that, of course, they've been beset by issues. But surprisingly, they also have a directorate of competition and consumer affairs. So there is something that, who knows, the Taliban may also be enforcing competition laws. We don't know, because a lot of information doesn't come out. What the book talks about, and what I discovered in my research, that whilst all these countries had adopted laws, the way they did it was very different. They engaged different institutions, they engaged different strategies for adopting these laws. And mera interest us process pe zyada tha. More than the outcomes and what was achieved later on, I was much more interested in what happened at the stage of adoption. Another point that I was quite sort of intrigued by was that adoption to ho gayi, and quite rapidly. We saw from 2002 to 2020, the entire region is covered. But enforcement was another story. So if you see the 2 largest bars, sorry, I went. The two largest bars here are Pakistan and India. They're the only two countries in the region that moved from adoption to implementation. The only two countries in the region जिन्होंने उस law को ना सिर्फ enact किया लेकिन उसको enforce भी करने की कोशिश की, जिसमें of course Rahat has played a very big role in that, and she'll be, I'm sure, talking to it in much more depth than I can. But the other countries, what we saw is they kind of enacted and stopped. So क्या हो रहा था कि law अहम भी बहुत है, लेना भी है, लेकिन कोई मसला भी है कि enact करने के बाद enforce नहीं हो रहा. So I was quite intrigued by that situation. So my book then is a story of competition law in South Asia in 9 chapters. So it's basically a 9-chapter story. Chapter 1, it's an academic book. I must warn you, it's not a light read. The academic book ki requirement, as you know, it's a theoretical framework hona chahiye. I have a theoretical framework. I draw upon several literatures. I'll talk more about that when we get into it. Chapters 2 and 3 spend a lot of time detailing the adoption experience of all South Asian countries, जिसमें ज़्यादा focus India और पाकिस्तान पे है, because उनके बारे में ज़्यादा information available थी, ज़्यादा documented थी उनकी सारी journey. And then the other 6 countries also, there was a lot of information available about them as well, but I had to literally pull it out. वो सारा है in 2 and 3. Chapters 4, 5, 6, and 7 are fully focused on India and Pakistan because that's the only space in which enforcement took place. And there's a lot of comparison. So I think instead of just looking at the Pakistan story on its own or the India story on its own, which has been done to some extent, not holistically, but had been done, but there was never a comparison to see what was going on. And I tried to do that. And I'll, of course, share that with you as well. Then chapter 8 moves back to the rest of the 8 countries. And although they have not gone to enforcement, we take the wisdom that whatever wisdom I was able to draw from the Indian and Pakistani comparison and then apply it to the remaining 6 countries to see what was happening there, what can happen there, how can they take advantage of their situation? Because I believe that there's always opportunity in every adversity. So वो कैसे अपनी एक, अगर वो implement नहीं भी कर पा रहे, कहीं फंस भी गए, तो situation का वो कैसे advantage ले सकते हैं, जो हम इंडिया और पाकिस्तान से सीख सकते थे. And finally, I end by talking about the future, which is if everybody is really serious about competition in South Asia, जिसमें multilateral agencies का बहुत ज़्यादा role आ जाता है, then what are the strategies? How can we go about making it a more serious priority in these countries? So basically, the thesis is very simple in the book. जो orange bars आपके सामने नजर आ रही हैं, it's the strategy and the institutions through which a country adopts its law generates the compatibility of the law with the context for which it is intended, also decides कि उस law की कितनी legitimacy है in the local context. And that compatibility and legitimacy then affects its enforcement. The theory being that the higher the compatibility and legitimacy, the greater the chances of the law being enforced. And vice versa, the lower the compatibility and legitimacy, the lower the chances of the law being enforced. This is just a theory. It was a hypothesis, and then this was tested. इसमें बहुत variations हैं, but they come out in the 8 countries that we look at. Okay, so why is competition law very, very important? इसकी छोटी सी history, आप ये 3 maps हैं. It's a story in 3 maps now. सबसे पहले ये US में शुरू हुआ. There was the Sherman Act in 1890. US के अपने मसले थे. It's a huge country. They had companies, railroad companies, oil companies that were really, really dominant. उनको trusts कहा जाता था उस जमाने में. तो उन्होंने फिर एक law बनाया जिसको anti-trust वो कहते थे, to actually combat the power of these big companies. And that was the original form in which the law was introduced. Actually, Canada was the first, but Canada का चूंकि इतना influence नहीं हुआ, so we go with US, adopted within 10 years of Canada, and US became very, very good at enforcing it in its early years and continues to be reasonably good. Europe was the second region to adopt, they call it competition law. And Europe की जो founding treaty है, Treaty of Rome, उसमें लिखा हुआ है कि competition is a critical factor in the European Union. So European Union को बनाने के लिए उन्होंने कहा कि competition होना चाहिए, free movement of goods होनी चाहिए, equal bargaining power सबकी होनी चाहिए, level playing field होना चाहिए, nobody should be able to overpower anybody in that through economic power of monopolies and oligopolies. But this was, we're talking about the Treaty of Rome is 1950, early 1950s. I think it was 52, if I'm not wrong. But where are we today? Today, it's the red map. hardly there's any country in the world that doesn't have a competition law. And that shows it's probably the single most highest proliferation इस law की है दुनिया में इस वक्त. It's not just कि South Asia ने adopt किया है, पाकिस्तान ने क्यों ले लिया, हम पाकिस्तान को criticize करें कि शायद हम World Bank के हत्थे चढ़ के हमने ले लिया. और no, it is a global movement, and competition laws or policies exist in more than 120 more than 130 countries of the world. You can see that there's some African countries that are left and one or two in South America, but even that may have been covered by the time I made this map. I downloaded this map rather. This was a couple of years ago, and quite possible that ab wo countries bhi cover honge. So it really makes you think that there's something about this law. It is what is this law trying to do, and why are countries so eager to adopt it? So what does competition do? What does competition do? Not what the law does. What is competition? The basic understanding is, and this is really competition 101. मैं आपको बहुत बोर नहीं करूंगी इसके बारे में, but I'm sure आपको पता ही होगा बहुत सी बातों का. But the idea is that more competition in an economy is good. That's the basic idea. आप सब PTCL के जमाने के हम phones का हम सबको पता है. जब एक सिर्फ PTCL होता था, हम PTCL के hostage होते थे. अब हम सबके पास options हैं. एक जब सिर्फ Mobilink होता था, Mobilink held us hostage. Now we have choices, and I know many people have several SIMs. So not only do you're not fixed in your choices. You can move around much more easily. सिर्फ अगर Coca-Cola होती है, आप सिर्फ एक soft drink पीते. But now you have so many more choices. What does that mean then? Means that competition jab hota hai, the resources in the economy are allocated more efficiently. They go to where they will be more productive. So this is a very basic economic advantage of having competition. It reduces the prices that you can offer to consumers. I'm sure hum sabke dilon pe scars hain of paying very high prices to Mobilink at one point, which we now don't have to pay because we just have more choice and we'll immediately get different package from somebody else, and that's competition in just one sector, and every sector can share a similar story. Competition में the ideal competition state में आपकी output improve होती है. That makes sense because आपकी resources बेहतर तरीके से allocate हुए. From our point of view, हम सब consumers हैं, we have more choice. And that seems a very obvious point, right? We have more choice when there's competition. We have less choice when there is no competition or less competition. The ideal also is that quality improve ho jati hai when there's competition in the economy. Why? Because everybody has to compete with each other. You know, Telenor has to compete with Mobilinks, otherwise you won't buy. Consumers vote with their feet. So just to stay in the market and be more competitive, they have to produce a better quality. And then that in turn then spurs innovation in the economy. आप बेहतर से बेहतर product बनाने की कोशिश करते हैं, या अगर product आप नहीं बेहतर बना सकते, आप बेहतर processes adopt करते हैं to maybe produce something in 5 days instead of 10 days. So in overall, the idea, ये सिर्फ I must say this is an ideal situation. This is not necessarily the actual situation, but this is the ideal situation, which is the textbook situation, जिसको कहा जाता है कि you should have competition in the economy because इसके बहुत फायदे हैं. Notice करें मैंने इसके कोई नुकसानात का यहाँ जिक्र नहीं किया है because that's not the topic of discussion, but नुकसानात भी हैं. Maybe that's for another time. So what does competition law do? Competition law क्या करता है? ये तो हमने देख लिया कि competition क्या है, अच्छी चीज है. हमने I hope you agree with me कि competition economy में होना अच्छी चीज है. Competition law की जो interesting बात है, जो मेरे students को कम से कम बहुत मुश्किल लगती है to grasp, that it is a reactive law, not a proactive law, which means it's more like a police than a governor. You know, police comes in when something goes wrong. Sometimes it comes in when something goes wrong. Let's assume that the police comes in when something goes wrong. The governor will tell you how to do things, right? वो आपको governance structure देगा. Competition law is not giving you a governance structure. It's coming in when something goes wrong. 3 मोटे मैंने situations बताई हैं जिनमें competition law will intervene. This is global, by the way. This is not talking about Pakistani competition law. This is all competition laws will do it with some variations. They go against, they say cartels or anti-competitive agreements are not good. And I'm using very layman language, and I'm sure Rahat is thinking, oh God, she can't say not good, but I will just say not good for now. Why are they bad? Because they're like ganging up. you know, and this is, I'm not creating these words, these research articles आए हैं to call these ganging up and bullying, and I'll explain that in a minute. अगर दो companies आपस में मिल जाएं, they gang up against the others, तो competition तो ना रहा ना, 2-10 मिल जाएं तो और भी खत्म हो जाएगा. तो every time you see people getting into what we call anti-competitive agreements or cartels, that's bad for the economy, bad for the consumer, bad for all the things we listed in the previous slide. That's when competition law intervenes. Competition law has the tools to go in. Similarly, bullying, जैसे हम कहते हैं, abuse of dominant position, अगर कोई कंपनी इतनी बड़ी हो जाए कि वो अपनी पावर exert कर सकती है इकोनॉमी के ऊपर, then competition law will come in. और वो भी, उसके भी बहुत specific circumstances हैं, which again, not for today. This is not a competition lecture. Mergers and acquisitions is the neatest area in some ways of competition, क्योंकि उसमें actually कुछ होने से पहले competition law जाता है. वो देखता है कि कोई ऐसी सिचुएशन तो नहीं बनेगी कि आगे जाके बुलिंग और अब्यूज कर सकें, आगे जाके इनका कोई मार्केट को ये कैप्चर कर लें, तो पहले ही उसको प्रीएम्प्ट करने की कोशिश करते हैं. सो दीज आर द 3 मेन एरियाज. बहुत सी कंपटीशन अथॉरिटीज, इंक्लूडिंग आवर पाकिस्तानी कंपटीशन अथॉरिटी, also has some consumer welfare, not welfare is the wrong word, but consumer protection के भी उनके कुछ idea, कुछ powers होती हैं. मसलन पाकिस्तान में deceptive market practices, US में उनका consumer protection and competition law is also in the same authority. FTC उनका इदारा है, excuse me, तो उनकी भी same authority में. So this is also quite a common institutional pattern. But this is what competition law does. I think the most important message to take away over here is that competition law only comes in when something goes wrong. It doesn't come in to create a good economy or a productive economy or an efficient economy. It assumes that the economy is good if it's running without interference. So it supports free trade and neoliberalism, and it only comes in when something goes wrong. So सिर्फ गलती को सुधार के वो फिर technically वापस चला जाता है. Again, ये बहुत contentious issues हैं. मैं आपको बहुत basic इसमें आपको दे रही हूँ insight. So मुझे कैसे ख्याल आया to write this book? It's a story which takes me to 3 cities. Started in Lahore in 2010. I was appearing in this very famous case, which figures in my book a lot, actually. Famous because it ran for a long time, and it was one of the biggest cartels that the Competition Authority, in its very early years, it went after it. The All Pakistan Cement Manufacturing case. Is case ki story basically, jo maine experience ki, the story is much bigger. I was appearing for one of the cement companies in Lahore High Court, aur wo case hamara takriban suna gaya. Justice Saqib Nisar was Chief Justice of the Lahore High Court at that time. We were literally 1 day away from a judgment when he was elevated to the Supreme Court. The case was part heard, went into a tailspin for many years after that. Tab tak main Pakistan se ja chuki thi, so I couldn't see the end of this case, but I think the case has now reached its final conclusion, but I parted at that time. But that case really, really got me thinking. I felt that there was the way the lawyers were dealing with it, har koi, I mean, humne constitutional petitions file ki nahi thi, but nobody would talk about the merits of competition. Jab hum bar room mein bhi baat karte the, people had a very limited understanding of what competition was. Ye kya bala hai? ये क्या कर रहे हैं? ये वेस्टर्न आइडियाज आ गए हैं, हम पे थोपे जा रहे हैं. देयर वाज अ वेरी लिमिटेड अंडरस्टैंडिंग. और जब कोई ऐसी चीज आप इनकाउंटर करते हैं, आपकी क्यूरियोसिटी जागती है, और मेरी बहुत जागी उस वक्त. इट स्टेड विद मी एज अ क्वेश्चन कि क्या हो रहा है. फिर वो हमारा लॉ ऑर्डिनेंस के तहत बना था, सो वो भी एक बहुत बड़ी, उस पर बहुत डिबेट हो रही थी कि लॉ ऑर्डिनेंस के तहत बन गया, इस पर तो कोई डिबेट ही नहीं हुई है, इसको तो पार्लियामेंट में जाना चाहिए था. ऑल दीज इश्यूज वर वेरी वेरी अलाइव एट दैट टाइम. इनफैक्ट हम लोगों ने एक आर्टिकल भी लिखा था PLD में 2007 में, raising all these grounds कि ये law नहीं बनना चाहिए था. I'm now all for the law, but you change and you should change. U-turns कुछ अच्छे होते हैं, and I took one at that time as well. उसके बाद I went to London to do a PhD in this area. मैंने I don't know why the slides are not fully visible. There's some issue with the setting. Can somebody check that, please? मुझे verbally याद है, मैं आपको बता देती हूँ कि क्या हुआ. I did a PhD from University College London, where I compared India and Pakistan's adoption and implementation to understand कि क्या adoption process के difference में हमने ordinance से law लिया, उन्होंने act से law लिया, क्या कोई उनके उसमें कोई फर्क आता है? उनकी strategy क्या थी law enact करने में, हमारी strategy क्या थी, क्या implementation में कोई फर्क आता है? I was very very curious about that, and कुछ फर्क था, लेकिन black और white नहीं था. So that was an interesting learning for me कि फर्क आते हैं, लेकिन इतने नहीं आते कि आप कह सकें कि हाँ जिसने लेजिस्लेशन उस तरह ली है वो तो ठीक रहेगा, अनैक्ट कर दें तो ठीक रहेगा, और पार्लियामेंट प्रोमलगेट करें ऑर्डिनेंस तो ठीक नहीं रहेगा. इट वाजंट दैट सिंपल, लेकिन उसमें कुछ सोचने की बातें थी. PhD, alhamdulillah, was completed in 2018. Then I thought, okay, what about the rest of South Asia? You know, I was very, very keen to understand कि बाकी मुल्कों में क्या हो रहा है. And then that was the journey of the book. So it started with that one idea कि India Pakistan की research हो चुकी थी, and then I had to take it to the next, to the remaining 6 countries, which I have listed, right? So you already know what they are. एक और जो बहुत इसमें ड्राइविंग फैक्टर था मेरे लिए वो ये था कि साउथ एशिया इटसेल्फ इज वेरी सिग्निफिकेंट. हम लोग एक्चुअली पाकिस्तान की बात इतनी ज्यादा करते हैं, नेचुरली हम पाकिस्तान में रहते हैं तो पाकिस्तान की बात करेंगे, कि हम ये थोड़ा कभी कभी इस बात को मिस कर देते हैं कि रीजन की एक अपनी बहुत सिग्निफिकेंस है. एंड दैट इज व्हाई आई वांटेड टू राइट अबाउट द रीजन. अफ्रीकन रीजन पे बहुत लिखी गई है, साउथ अमेरिकन रीजन पे बहुत रिसर्च है, साउथ एशिया पे नहीं थी. कंपटीशन को समहाउ इंपॉर्टेंटली नहीं लिया जाता. नोबडी हैड डन दिस रिसर्च, बट ये बेसिक फैक्ट्स हैं जो आपको तो पता है. आई एम नॉट गोइंग टू नेसेसरली रिपीट देम, बट फॉर अ वेस्टर्न ऑडियंस आई हैव टू मेंशन these facts, and I'll simply do it for you as well. So South Asian as a region is a global player. हमारा income remittances में share, population में share इतना ज़्यादा है दुनिया की कि we have to take ourselves more seriously. हम unfortunately we are a poor region, you know, and that also makes it very important then to consider, do we need this law, and if we need this law, what kind of law do we need? और अगर ये law हमारे लिए इतना अहम है तो हम इसे enforce क्यों नहीं कर पा रहे? Right? We are a poor region. Why are we not taking all the help we can get from these laws? And finally, we are a region that has been, मुझे तो कभी कभी लगता है over-helped. एक तो होता है ना help करना किसी की, दूसरा होता है over-help कर देना. All the multilateral agencies are involved in what we do here. So we get reform guidance from World Bank, IMF, ADB, UNCTAD, you name it. It's shocking. इतने ज़्यादा हैं और sometimes they're not even agreeing with each other. So ये 3-4 factors थे which make this region very, very important. And of course, I am South Asian, right? So मुझे लगता था मुझसे बेहतर कौन समझ सकता है. हो सकता है आप कहें कि नहीं, आपसे बेहतर हम समझ सकते हैं क्योंकि आप यहाँ रहती नहीं अब. But मुझे लगता था, at least in that space, living in the UK, कि वहां पे कोई नहीं समझ सकता जो बात मैं समझ सकती हूँ. So I need to talk about something I understand. फिर कंपटीशन इटसेल्फ जो पूरी बॉडी ऑफ वर्क है उसमें ये बात, उसमें काफी गैप्स थे. जैसे मैंने आपसे कहा, साउथ एशिया पे कोई रिसर्च नहीं थी एज अ रीजन. अंदाजा ही नहीं था. वो साउथ एशिया को कहते थे साउथ ईस्ट एशिया, व्हिच मींस totally different set of countries. They just didn't know. And that's because I think we present ourselves mostly in conflict. When we talk about South Asia, we present ourselves in conflict with India. So वो सब समझते हैं India Pakistan conflict. Regionality कोई नहीं समझता, बात ही नहीं होती उसके ऊपर. So that was a big gap. दूसरा जो एक गैप मुझे नजर आ रहा था कि when we talk about competition law, तो हम उसकी economic outcomes की बहुत बात करते हैं और सक्सेस और फेलियर को इकोनॉमिक आउटकम्स पे जज करते हैं. लीगल आउटकम्स की हम बात नहीं करते. बीइंग अ लॉयर, बीइंग ट्रेन्ड एज अ बैरिस्टर एंड देन विद अ पीएचडी इन लॉ, इट वाज इंपॉर्टेंट फॉर मी कि हम लीगल आउटकम्स की बात करें. पॉलिटिकल लीगल और कॉन्टेक्स्ट का हमें अंदाजा ही नहीं. हम बिल्कुल एक आइसोलेशन में बात करते हैं कॉम्पिटिशन लॉ की, एज इफ इट्स सम सॉर्ट ऑफ अ टेक्निकल थिंग जो खुद से ही exist करेगी. It's not existing in a context. So I wanted to bring it to the political economy of competition कि ये एक एयर में नहीं, थिन एयर में नहीं एग्जिस्ट करता है. इट गोज इनटू अ प्री एग्जिस्टिंग कॉन्टेक्स्ट जहां पे उसको प्री एग्जिस्टिंग इंस्टीट्यूशंस के साथ काम करना पड़ता है. किस हद तक वो सक्सेसफुल हो रहा है उसको करने में. सो या दीज वर, आई मीन आई हैव मोस्टली कवर्ड these were some of the thoughts जो मुझे काफी ज्यादा गैप्स नजर आ रहे थे, which I thought this book will help cover. So that now brings me to what was the framework of analysis. So I find this, I'm not a scientist. I've never been I was a science student once in O levels. Uske baad se nahi hu. But I find this diagram really, really useful to explain what happens and why context is important. तो ये जो beakers में आपको yellow, orange और green नजर आ रही है tubes में liquid. I think these are like the model laws that exist in the world. मसलन अमेरिका का लॉ है, यूरोपियन यूनियन के हर मुल्क के पास अपना एक लॉ है, फिर यूरोपियन यूनियन का अपना लॉ है, और भी मुल्कों के लॉज हैं. दीज आर द मॉडल्स. मॉडल्स बहुत अच्छी चीज है. वी शुड नॉट ट्राई टू रीइन्वेंट द व्हील. जरूर आप एक मॉडल को लाएं, लेकिन मॉडल को जब आप लाते हैं तो फिर आप उसको अपने हिसाब से उसको अडेप्ट करते हैं और उसको देखते हैं, उसको परखते हैं, उसको एनालाइज करते हैं. आप कई मुल्कों के मॉडल्स को कंबाइन भी कर सकते हैं और आप हो सकता है एक ही मुल्क का छापा भी मार सकते हैं. बट इट इज स्टिल अ स्ट्रैटेजी. ये अनथिंकिंग चीज नहीं है, ये उस बड़े बीकर में हो रहा है कि वहां पे वो मिक्सिंग हो रही है, और वो मिक्सिंग से फिर जो प्रोडक्ट निकलती है, देन दैट इज अ न्यू लॉ. एंड नोटिस दैट इट्स अ डिफरेंट कलर. It might have all the ingredients, but it is something new because it has been colored. और मैं तो आपसे यहां तक कह रही हूं कि अगर आप 100% भी छापा भी मार देंगे ना, it will still be a new law because लफ्जों के मीनिंग डिफरेंट लोगों के लिए डिफरेंट होते हैं, और the context in which they operate is different. So it is always different. We all have hands, right? हम सबके hands can fit the same definition, but everybody's hand looks different. And that is how every law is different because it's unique to its context. And lafzon ke meaning, legal lafzon ke meaning are different in different countries as well. So these are all important factors. And this is the continuum I wanted to study. So I wanted to study कि किस क्या मॉडल था, उसको किस स्ट्रैटेजी से हमने अडेप्ट किया और उसका एंड क्या निकला. So this is why this picture is important to me. So anyway, I will not go through this in too much detail, but suffice it to say that this was perhaps the most rewarding part of my research, which was to create a theoretical framework. When I started this research, मुझे लोगों ने कहा भी और मुझे भी अंदाजा हुआ कि there is no single literature that exists जो पूरे continuum को capture कर सके. So legal transplant literature था, comparative law का literature था, जो कि सिर्फ transplant को देखते थे, चल रहा है नहीं चल रहा है, वो बीच में खड़े थे. उसके बाद न्यू डेवलपमेंट इकोनॉमिक्स वाले थे जो कहते थे ओके, इंस्टीट्यूशंस मैटर अ लॉट. आप किन इंस्टीट्यूशंस के तहत लॉ बनाते हैं या कोई इकोनॉमिक इंस्टीट्यूशन बनाते हैं, दैट मैटर्स अ लॉट. फॉर इंस्टेंस, इनकी एक बहुत बड़ी कंट्रीब्यूशन थी कि जो भी लॉज बॉटम अप, पार्टिसिपेटरी और इंक्लूसिव इंस्टीट्यूशंस के तहत बनते हैं, उनका चांसेस ऑफ बीइंग मीनिंगफुली इन्फोर्स्ड इज हायर. और जो लॉज टॉप डाउन एक्सक्लूसिव मेथड्स के थ्रू बनते हैं, उनके चांसेस ऑफ बीइंग एनफोर्स्ड मीनिंगफुली आर लोअर. उनकी कंपैटिबिलिटी लोअर होती है, उनकी लेजिटिमेसी लोअर होती है. सो लेजिटिमेसी वाज समथिंग न्यू व्हिच स्टार्टेड कमिंग अप फॉर मी. मैंने कहा ये तो इसका लॉ की किताबों में तो इतना जिक्र नहीं है. दैट टुक मी देन टू पॉलिटिकल साइंस जो जिक्र करता है लेजिटिमेसी का, एंड आई देन स्टार्टेड ड्राइंग अपॉन लिटरेचर्स ऑफ डिफ्यूजन एंड ट्रांसफर, जो कि इससे पहले हमने लीगल ट्रांसप्लांट लिटरेचर में नहीं ऐड किए थे. बहुत सी मुझे रिसर्च इसमें मिली कि दोनों को कंबाइन करना चाहिए, लेकिन लोगों ने किया नहीं था. सो वी ट्राइड टू पुट दिस टुगेदर. उसमें यह फायदा हुआ कि जो डिलिबरेशन की स्टेज होती है, जब हम लॉ के बारे में सोच रहे होते हैं, उसमें उन्होंने बहुत सी इंसाइट दी. उस लिटरेचर ने कहा कि तकरीबन 4-5 मेन स्ट्रैटेजीज होती हैं लॉ को अडॉप्ट करने के लिए. दे कैन बी आप एम्यूलेट कर लें, उसके कई और लफ्ज भी वो यूज करते हैं. आई एम जस्ट गोइंग टू यूज दीस 4 मेन कैटेगरीज. यू कैन जस्ट कॉपी, यू कैन मिमिक, यू कैन एम्यूलेट. उसमें भी वो जैसे कहते हैं ना उर्दू में, हमके नकल के लिए भी अकल चाहिए होती है. दैट्स आल्सो नॉट अ ब्रेनलेस एक्ट, बट इट जस्ट शोज कि आपने ले लिया, जैसे लिखा हुआ था आपने ले लिया. सेकंड, आपने सोशलाइज किया. दैट मीन्स यू टुक द लॉ, यू अडेप्टेड इट, यू मेड इट योर ओन. थर्ड, आप पे कोअर्जन हो गई. कोअर्जन बाज लोग इस लफ्ज का बुरा मनाते हैं कि जी हमें तो कोई कोअर्जन नहीं हुई. कोअर्जन इज नॉट माय वर्ड, इट्स अ वर्ड इन द लिटरेचर. ऑल इट मींस इज कि यू वर परसुएडेड बाय सम एक्सटर्नल फोर्स, आइदर थ्रू अ ट्रीटी और अ डोनर कॉन्ट्रैक्ट और अ वर्ल्ड बैंक लोन. आपको जेंटली परसुएड किया जाता है कि ये लॉ होना चाहिए आपके पास. ओके, आई एम श्योर यू कैन ऑल थिंक कि हम कहाँ पे फॉल करते हैं इसमें. और फिर रेगुलेटरी कंपटीशन, ये एक बड़ी इंटरेस्टिंग बात है कि अगर आपके नेबरिंग मुल्क अडॉप्ट कर रहा है तो शायद आप भी करें, बिकॉज यू डोंट वांट टू बी लेफ्ट बिहाइंड. एंड सर्टेनली साउथ एशिया में रेगुलेटरी कंपटीशन भी हुआ है. सो दिस लिटरेचर गेव मी अ लॉट ऑफ इंसाइट टू help understand what happens at the deliberation stage. Deliberation में हम कौन सी strategy adopt कर रहे हैं, हम कौन से institutions के तहत ये काम कर रहे हैं. For instance, पाकिस्तान में ये किसने बनाया, कौन से इदारे इन्वॉल्व थे इस लॉ को बनाने में, इंडिया में कौन से इदारे इन्वॉल्व थे. सो इट रियली गेव मी अ वे ऑफ लुकिंग एट दीज इंस्टीट्यूशंस. फिर फॉर्मल इनैक्टमेंट के टाइम पर कौन से इदारे इन्वॉल्व थे, कौन सी स्ट्रैटेजीज इन्वॉल्व थी, क्या कोई डिलिब्रेशन हुई या नहीं हुई, किस इदारे ने की, वो इदारा क्या बॉटम अप पार्टिसिपेटरी था या टॉप डाउन एक्सक्लूसिव था. सो दैट you got a lot of way to strategies of looking into diagnostically examining this. Finally, you then look at the enforcement, and उसमें भी फिर बहुत फायदा हुआ from a new institutional economics. That was the only literature that linked adoption with implementation, and they said कि अगर चीजें आपने bottom up participatory inclusive institutions के through ली होंगी तो chances of success are higher. ओके सक्सेस मैं मेजर नहीं करना चाहती थी. व्हाट वाज सक्सेस हम इकोनॉमिक आउटकम्स में नहीं देखना चाहते थे. वी वांटेड टू सी इट एज अ लीगल इंस्ट्रूमेंट. वो क्या सक्सेस है. सो हाउ डू यू डिसाइड अ लॉ इज सक्सेसफुल. अगेन द थियोरी सजेस्टेड that a law is successful when it is utilized and understood and applied in the country. And the second criteria was that a law can be considered successful when it interacts productively with the pre-existing legal institutions in the country. So ये दो मेरे पास measures थे success के, and with this framework I was then ready. This took me a long time. This was probably the most challenging but also the most rewarding part of the work. And with this I started looking at the data. Data was आपको मैंने जैसे पहले भी बताया कि और मुल्कों में तो कोई analysis decisions हुए ही नहीं थे. So I had to look at the antitrust decisions. So notice not merger decisions. I was only looking at जिसको मैंने ganging up और bullying कहा था. I was looking only at anti-competitive agreements and abuse of dominance over a period of 2008 to 2020. इंडिया ने कुछ भी काम नहीं किया था literally till 2010, लेकिन पाकिस्तान ने काम फौरन शुरू कर दिया था 2008 से. तो we had to start from 2008. Mergers इसलिए नहीं किए क्योंकि इंडिया में merger regime बहुत late आई. There was not enough time to compare. All decisions were examined, all decisions were catalogued. अपील्स को इसलिए नहीं किया क्योंकि हमारा अपेलेट ट्राइब्यूनल 4 दिन जागता था, 4 दिन बंद होता था. वी कुडंट फाइंड द डेटा ऑन दैट. सो अभी तक उसका डेटा पब्लिश नहीं होता कहीं पर. कोई बता दे, कोई अल्लाह का बंदा कि आज ये ऑर्डर आ गया है तो मिल जाता है, अदरवाइज इट्स वेरी हार्ड. So that was one big data set which I examined. ये raw data था. I had to create indicators myself and categories. उसके अलावा I looked at a lot of the writ petitions that were filed from decisions of the various competition orders. ये writ petitions आप imagine करें इंडिया में तो I don't know them over 30 high courts, very difficult to find. लेकिन competition decisions के अंदर ही कई रिकॉर्ड भी नहीं थी क्योंकि वो जब अपनी हिस्ट्री लिखते हैं तो उन्होंने रिकॉर्ड की हुई थी. तो वी गॉट टू अंडरस्टैंड कि किन किन केसेस में रिट्स हुई, किन किन केसेस में फैसले आए, किन किन ग्राउंड्स पे फैसले आए. सो कंपेयर दैट विद इंडिया एंड पाकिस्तान एज वेल. और दोनों का फिर कंपैरेटिव एनालिसिस था. सो इंडिविजुअल भी था, देखा गया कि क्या हो रहा था, बट देन बोथ वर कंपेयर्ड एज वेल. सो व्हाट वर द मेजर फाइंडिंग्स. I'll just focus you on this picture. The major finding was that to be successful in a country, to be successfully enforced in a country, a competition law should be compatible with that country. Language की भी एक compatibility होती है, concepts की compatibility होती है. It should be understood and it should have legitimacy. Legitimacy कहाँ से आती है? That really comes from how the law is enacted. एक तो तरीका होता है कि आप उसको democratically enact करें through parliament. बाज़-औक़ात वो एक बुरा तरीका है because अगर उसमें जाएंगे तो शायद law enact ही ना हो. A lot of people told me that अगर पाकिस्तान में हम act का wait करते तो business interests would never have let this act be enacted. And this is not just true for Pakistan, this is true for many, many developing countries where business interests are so powerful कि वो अच्छे laws भी ना आने दें. तो फिर आप legitimacy कहाँ से लाते हैं? फिर आप लाते हैं through decisions and through enforcement. You bring about that greater legitimacy, or through advocacy. जो कि I think the risk. Can we stop this? I think it's drilling outside, right? So compatibility and legitimacy are important. Legitimacy की जो एक interesting बात है क्योंकि it has two faces. A lot. Sorry, yeah, I am. So legitimacy के two faces हैं. One is international and one is domestic. तो पाकिस्तान, for instance, या बहुत से मुल्क, I don't want to pick on Pakistan at all because Pakistani enforcer मेरे पीछे ही बैठे हैं और कुछ भी हो सकता है यहाँ पर. But a lot of countries adopt laws to gain international legitimacy. कि भी दुनिया में नजर आए कि भी हमने तो, हमारे पास तो लॉ है, we are looking good guys, we are members of the international community. लेकिन एक डोमेस्टिक लेजिटिमेसी भी होती है जो कि आप अपने लोगों को कॉन्फिडेंस में लेके हासिल करते हैं. दोनों जरूरी हैं, आपको दोनों चाहिए. इंडिया वाज बेटर ऑन डोमेस्टिक, वी वर बेटर ऑन इंटरनेशनल. लेकिन उल्टा हो गया, इंडिया को लेनी पड़ी इंटरनेशनल लेजिटिमेसी, अपने आप को उनको सॉर्ट आउट करना पड़ा है और पड़ता रहेगा. और अब तो बहुत कर लिया उन्होंने, बहुत हद तक कर लिया है, 100% ही कर लिया मुझे लगता है. और हमने शायद, आई थिंक हमने भी बहुत हद तक, हम अब एक, जैसे आई थिंक नो बिजनेस पर्सन इन पाकिस्तान विल से दैट कॉम्पिटिशन इज नॉट इम्पोर्टेंट फॉर देम. उसकी immediate अब due diligence होती है. So ये दोनों चीजें साथ साथ चलनी. The other very important point to understand, and I think this is really the point for me, the greatest hope in this work is in the point कि compatibility और legitimacy कोई static चीजें नहीं है कि होंगी या नहीं होंगी. ये create होती हैं, enhance होती हैं, ये grow करती हैं. और अगर हमें पता हो कि हमने किस direction में जाना है, तो we can grow them. Right? So it is never a point of despair. And that to me was the biggest learning. So if you remember, I said that its adoption institutions do matter. They do matter, but they don't matter to a point where everything is lost. So it's not black and white, it's gray. But then why is this research important? Because it helps you navigate the gray area. कि आपने इसमें से निकलना कैसे? Like अगर आज compatible नहीं है आपका law, जैसे हमारा law है, वो exactly उस language में लिखा हुआ है जिसमें EU competition law लिखा हुआ है. लफ्ज पर लफ्ज. तो उन लफ्जों की मीनिंग भी नहीं पता थे. I remember when I appeared before my first competition hearing before the members of the competition commission, and I tried to use some contract law principles, and the honorable member who is now was also the honorable chairman later, she said, this is not relevant here. This is contract law. That was news to me. It was not known to me as a barrister that I can't use, because law में तो हम यही करते हैं, हम principles adopt करते हैं when the word is not defined in the law itself. So ये एक language का एक compatibility through decisions create हो सकती है. Legitimacy through advocacy, through decisions, through greater interaction with lawyers create हो सकती है. So to me, that is the most important point, that legitimacy and compatibility are not static, they are dynamic. And finally, that both together impact the way we respond to the law. So as the law grows in compatible, and you will, those of you who might know Pakistan, maybe I'll tell you the story at some point. 2000, एक certain point पे आके हमारा competition law में कुछ नहीं हो रहा था. We just became very, very quiet. और उस वक्त हमने फिर अपनी advocacy बहुत शुरू की. ये इंडिया में भी हुआ है. ये बहुत मुल्कों में हुआ है कि एक certain point पे आप hit करते हैं. Rock bottom. And that's when you go back and you start creating. Maybe aaj jo kar rahi hu, even though I'm not employed by anybody to do this, but it is competition advocacy. I am talking about competition and creating greater awareness. So that is what you do when you feel that you need to grow in a certain area. So these were some of the major findings. Again, aap logon ko iski, I don't have to go into too much detail at all, but ek chapter. So this was all discussed. Ke compatibility and legitimacy affects the way the system is operationalized. It affects the kind of challenges that are brought against the law. It affects how the law is interpreted. It affects even the penalties that you're going to impose. For instance, India में उन्होंने domestic इतना उन्होंने अपना अच्छा carve out किया हुआ था system that they were so domestically comfortable कि वो penalties ही नहीं लगा रहे थे. They didn't want to alienate anybody because they were too entrenched domestically. They had to move out so that they had to align themselves with international powers. So ये भी एक बड़ा thing था. पाकिस्तान में इतनी कम understanding थी law की कि पहले सालों में सिर्फ suo motu, I mean सिर्फ तो नहीं but बहुत ज़्यादा, very high percentage of competition matters were only suo motu, because the only people who understood the competition law was the competition authority. Nobody else understood it. So ये सब rebalance करना पड़ता था, but these are things that happened. And courts में सबसे ज़्यादा जो interesting चीज़ नजर आई कि हमारे courts बहुत reluctant थे competition matters को touch करने के लिए. They were completely unaware. किसी point पे उनको समझ ही नहीं थी क्या हो रहा है. And they would simply say, they would use the point about, oh, ये तो ordinance है, अच्छा फिर act आ जाएगा, फिर देख लेंगे. But actually not lawyers, not judges, nobody really understood. And I don't think that is the situation 10 years later. But that was the situation because law हमारा बना बहुत जल्दी में. We enacted it very quickly. India ने 2-3 साल लगाए उसको समझने में, उसको debate करने में. हमने 6 महीने लगाए. 2 meetings हुई national level पर. India की पता नहीं कितनी meetings हुई. And this makes a difference. Again, important point is it's not a 100-0 difference, but it's a difference that needs to be carried through your operational phase. So finally, I think वही जो बातें मैं आपसे कह चुकी हूँ कि there is no magic formula for success. Each country has to assess where they are and then devise their own strategy for success. Success is incremental, so you're not a prisoner of your destiny. अगर आपने एक तरीके से कुछ काम कर लिया तो for the rest of your destiny, you don't have to keep beating it. You can change it. You can recharge your progress. And understanding the link between adoption and implementation helps you understand where you want to intervene. Understanding the strategy, for instance, India ने चूंकि बहुत socialize कर लिया था, तो उनको अपने आप को करना पड़ा किसी point पे emulate भी करना पड़ा West को, क्योंकि West से बहुत दूर चले गए थे. Eventually, this was a law that needed to be connected to the West. Pakistan ने बहुत ज़्यादा emulate किया था शुरू में. It needed to socialize a bit more, make it more Pakistani. ये दोनों चीजें साथ-साथ हो रही थी, and they were being rebalanced. But the important point is, understand where you need to intervene and then intervene appropriately. So this is the last set of, well, I think it's the last slide, not even the set of slides. So what do I hope will happen? The relevance of this work is not just for South Asia. It's for all developing countries, and it's actually for multilateral agencies as well. Competition authorities can definitely benefit, क्योंकि उनको कुछ इसमें case analysis भी बहुत ज़्यादा है. Cases are actually analyzed, but there's also a lot of theoretical understanding of the issues. Government bodies engaged in law reform can definitely benefit, especially from the theoretical understanding of how economic laws are adopted and where we can intervene. So कहने को मैं competition law के transplants की बात कर रही हूँ, but this applies to any law that we borrow from anywhere. आप कोई भी law borrow करें, आप वही diffusion strategies adopt करेंगे, वही institutions आप लाएंगे, आप कैसे उसको बेहतर बना सकते हैं, आप कैसे compatibility और legitimacy generate कर सकते हैं. So that's a big benefit. And finally, all the multilateral agencies like World Bank, IMF, ADB, UNCTAD वगैरह जो इस process में involved हैं, developing countries को advise करती हैं, उनके लिए ये बहुत अहम है, because they need to understand, and they do understand, but they need to understand it from us, from our voices, that it is not enough to just give us a law that we can keep on our books. If you really want, if you say, if these multilateral agencies, and we spend, they give us a lot of aid, and you know this, मुझे ख्याल एक मिनट की लगा मैं student से बात कर रही हूँ. They give a lot of aid which we pay back to them for their technical assistance. So इतना जो हमारा पैसा खर्च हो रहा है, then why are we not reaping the benefits? They need to understand how to pitch the support to us, ताकि हम अपने laws को जो enact कर रहे हैं उनको फिर meaningfully enforce भी कर सकें. Otherwise, what we're doing is we're just playing in that vicious cycle of aid and dependence and not really getting out of it. So I think that's it from me. I hope that was not way too long. Probably was. You should have warned me at some point. But thank you very much for listening. Nobody fell asleep, so thank you for that.
Thank you so much, Dr. Darr. I think that was a great overview of the book. You can tell that you get around to reading it. And so thank you for that, Dr. Darr. I'd like to move to Ms. Rahat for the next stage of this. Ms. Rahat can maybe shed some light on the practitioner side of the equation and how these things sort of actually sort of play out on the ground in terms of your own experiences and otherwise. So Ms. Rahat, please. Thank you.
Assalamu alaikum, everyone. First of all, I would like to congratulate Dr. Amber for taking up this subject and doing her PhD on the competition law, because as she said, she was amongst one of the few lawyers, along with the current one of the Supreme Court judges and one leading corporate law firm, that they had written a paper as to the flaws and challenges that this law would face. I'm happy to hear that she's taken a U-turn, and this was a nice thing. You see, we all accept that where we learn and grow. So this was quite a, when I heard that she's written a book, I was really happy that at least this is a victory for competition law, that she's accepted its relevance. But coming, when I read the book, and I must say, I could not have gone through the tediousness of it in terms of it's an academic research, but fairly well, if you look at it, how I have underlined and looked at the entire aspects of it. I have my disagreements, to say the least. And I did feel that it was more of a cartel lawyer than an objective perspective, taking into account the regulatory aspect as well as the practitioner's aspect, as well as the international aspect. So any perspective, I might have a different perspective as a practitioner or as a regulator. And I'm admitted, I'm willing to accept that bias. But there are some, I feel that there is inconsistency in what is being proposed and what is being concluded. So there are certain aspects, and I hope, since this is a very candid forum, so please don't take it as I am pitching against this whole thing. I do accept this is a good initiative and we need to build upon it. And there are certain areas I have noticed where I feel there could have been more things to address, to deliberate. And also I feel very, very strongly, if I may say so, that some of the decisions that have been pointed out as being inconsistent or not being followed have not holistically been quoted or understood. But then this is the beauty of law, that you always has two sides of the story, and then that's how for the audience to decide. So I would really urge the audience to refer to those decisions to read and form their own view. You see, as an authority, you can have two views. As an authority, you cite something, and two is a common sense approach. Law is 99% of common sense. So it wouldn't make that difficult for an economist or a lawyer to read and form your own opinion if it is a speaking order. And again, I had been saying it at various forums that we don't write speaking orders, we write shouting orders. So it's one of the grievances held against us. One of the things that is pointed out in that is that you rely too much on international precedents. Now, this point has to be understood in the context of why is there competition law in over 125 countries? Why? Why it is the most dynamic law, admittedly, as quoted by her and internationally accepted? Because it is relevant to all. Because competition law regulates behavior, and behavior across global jurisdictions, if you look at it, remains the same. So she was right. We don't have to reinvent things. When you follow the settled things and the settled principles, the thing is not that you're negating and saying that you are not indigenizing it. It's more so that you are going with the proven wisdom, the collective wisdom, what is best. So I look at it differently than when Pakistan took it, and I'll come to the top down and bottom up approach that goes through the entire book. And I'll see the problems that arise in law or in a book or in competition. There's nothing which is called wrong and right, but you have to assess it on the basis of plausibility of the arguments. So I would have loved to take just one cement case and go through it. It would have taken an hour to make you understand the whole perspective, how the cement industry works. But we don't have that time, and I totally understand and respect it. So let's go one by one. I would at the outset just quote a few things which are missing, so that we know why is it missing. Now, if you take the essential framework of this entire theory or the proposal that she has placed before in this book, the theoretical framework, which goes till the end, is that it warns against borrowing of law. It says that laws must have compatibility. It should have legitimacy. And in its adoption of law, if it is coerced, and she explained what coerce means, that it just is introduced by, let's say, multilateral agencies, World Bank, IMF, and rather than it is deliberated upon by the domestic institutions themselves and an initiative that is local, how it actually eventually leads to its effective enforcement and implementation. The word, and I'm glad that you clarified that you're only talking about the effectiveness as a legal instrument of law and not in terms of its economic impact. So we are closing that debate over here. Okay. So what I feel, 4 or 5 things at the outset that I think are important that have missed out. When you're talking about the region, and then you'd say, and by your own chart at page 79 of my book that I have, you have said 50% of the South Asian countries have a bottom-up approach, and the remaining 50 have top-down. Amongst these 8, there are only 2 who have worked: India and Pakistan. So the rest So 50% has worked, 50% it hasn't worked. And where they are in Afghanistan and Bhutan, we still do not have the law. We may have competition policy. The bill might be there. The bill in Afghanistan was there in 2012 as well, right? So I don't know by this, how do we interpret between just the two agencies who have passed it, that something would work out well in this region? It remains a question mark and yet to be tested. I would like to refer to a 2010 article, I think it was by Donald Rosalind, in which there was a hare and tortoise story. And then he himself said, stating that Pakistan is a success story and India has yet to start. And by the way, it's very important to understand, India was the first one that took a domestic initiative or a local initiative or whatever you may like to in choice of words, I'm not that good, in 2002. And until 2009, it had not passed a single decision because for the first 5 years, they kept it, certain part of it for advocacy, and then only they would try enforcing it. But they took more than that. They took 7 years before they could enforce it. Unlike Pakistan, where it came through an ordinance. Now, please try to understand it didn't come in 6 months. And that's not the correct picture. Yes, as other corporate laws, if you look at between from 60s to 80s, whatever laws have come, they are all top down. Most your company law, even the monopoly restricted trade practices ordinance, the competition, they've all come not through the parliamentary debates. So in Pakistan, what we are missing is there is an anomaly. All laws that have actually come in the corporate sector dealing with the economy have only worked during that regime. If that would have been the test, then none would have worked out for us. So that's not a theory, perhaps, that one can entertain. The second thing is, what are we, if we are looking at the South Asian law, I would have expected what would be the best regional model, taking the best of all, and what perhaps could be a best regional model for us to adopt. That could have been something for consideration. And then I'm not saying this is right or wrong. I think this could have been of interest to us. Then what is totally left out, I would say, is the unique set of challenges that CCP had to face. Those challenges are not even present in any of the countries that is mentioned here. Yes, we started as an ordinance, again repromulgated as an ordinance, again repromulgated as an ordinance, and then the act came. What would have been, I perhaps think it could have been of help to make the reader understand that in this whole process, the additional challenge for the agency was to defend its writ while enforcing the law effectively, and which it managed to do. This is a separate question, whether it was aggressive, assertive, or not. But I am not quoting myself. You can pick up any of the best jurists and see that enforcement in competition law has been termed as the best advocacy. Actions speak louder than words. So if you will keep creating awareness, what will you create the awareness about? Unlike if you have enforced certain decisions, you have shown how it has been implemented, it will be much easier for you to explain, this is what went wrong, this is how it had the impact, and that is why we have enforced it. There are always two sides of the argument, and I don't wish to say someone is wrong or right, but I'm just sharing a perspective. Because I am not an academic, I'm a practitioner, right? So as a practitioner, what were the challenges? So if you do not take into account the challenges of any agency, can you evaluate its performance? I don't think so. That would be fair. Then comes, how do you link the real reason behind effectiveness and how you justify? What is effectiveness? What are the parameters of effectiveness? You see, whether initially, obviously in a case where it is top down, you have to start your cases on on your own initiative. I don't like using the expression suo motu. It's too big and mighty, and it only suits the courts. So it had to start looking at things on our own because we had to take a proactive approach. It is very interesting to see that while the book refers to the peer review, it does not take into account any of our international ratings, global competition review, in which we had offered ourselves for independent evaluation. I do not wish to, and I don't want to take time, but a few things that I just want to share for record. I, out of my 12 years, have served 9 years with CCP. I was one of the first members where I served as member legal. Then from 2010 to 2013, upon the recommendation of Mr. Khalid Mirza, I was also made the chair. And after 7 years, in 2020, I was again invited to apply and to become the chair, right? What is it that we did during that time? This transition took place during my first term. We had to do effective lobbying. Obviously, it had to be done by the parliament, but we had to do a lot of lobbying against the vested interests. In that process, there were 14 amendments suggested before the ordinance was transitioned after its third promulgation into an act. And those 14 amendments that were debated in the Senate committee, the Finance and Revenue Committee, you know whom we had to sit with? Whom perhaps most of the people will call stakeholders. We need to draw a distinction between people who are stakeholders and people who have vested interests. It was the All Pakistan Cement Association manufacturers with whom we had to convince them. And I found it really interesting that in the parliament, we had to sit with them to convince that this law is good for them. In any case, out of the 14, we managed to only accept 4. And as member legal at that time, what were those 4 amendments? I don't find a mention of those amendments, of how this law has actually evolved, what we have taken. And is it an issue even right now that after the validation by the Lahore High Court on the constitutionality aspect in October, while the data presented here includes 2020, it doesn't really clarify whether it's July 2020 or December 2020, because the whole picture has changed since then. So that would have been important to clarify. And also the data relied upon in comparison to the CCI decisions and CCP, it conveniently ignores the first 7 years, it's 2002 to 2008. Why it's not that taken into account? Just because they were not enforcing, but the law was very much there. See, we cannot forget that. The second aspect is that the number of decisions, the data resource is not mentioned. I know for sure that in the annual report in 2011, there were 14 decisions. It mentions 2. So there is data inaccuracy, which needs to be rectified. And obviously, she must have taken from somewhere. I don't know from where. But never during my time, I was ever asked to provide that data. I'm grateful to her for mentioning that she had met all the heads and everything. But had she asked anyone for the data, that still can be provided, that should have been provided, and we needed to look at it. So in those these 2 terms that I particularly want to highlight, we had the law transitioned, right? And also the pace of enforcement was the highest. So in the first 3 years, if we had imposed, and I'm not saying, please don't get me wrong, कि जी हमने 7 तरफ fine लगा दिया तो बड़ी कोई enforcement कर दी. नहीं, I don't mean that. But there is a way and parameters with which you see how many show cause notices, how many search inspections, how many orders passed, and you look at it. In comparison, when you are doing all this, you've not taken into account the size of the population as well, and the size of the agency as well. That's also important. So how do we establish that whether it was through deliberation, through your own initiative, or it was imposed by a bilateral, multilateral international body, I don't find the link between effectiveness. Yes, I cannot deny that had we started as an act, the set of constitutional challenges would have been less, right? So now, so there's no regional model that we can look at. There is nothing that can prove this has worked out best in the region. Challenges for CCP has not been taken into account, and why we have not really addressed that the enforcement is linked with the political will. Where do you look at it? See, baki har cheez chhod de. Although in Pakistan, it also matters who is heading the agency. I mean, I'll be very candid about it. Because हमारे यहाँ institutions तो बनने ही नहीं देते हम. उसको हम lend ही नहीं करते कि वो हम strengthen ही नहीं करते. तो eventually हम drive होते हैं from the leadership. जो इस तरह की leadership आती है, हम उस तरह चलना शुरू हो जाते हैं. But मैं उस चीज को निकाल देती हूँ. When the law came, for whatever purposes, there had to be that political will to allow that कि ये ordinance promulgate हो जाए. उसके बाद, the way it has worked, what are the factors that have impacted? Why are we so generous and why are we so cordial when it says कि हाँ, the courts have been reluctant to do that? Really? When on one hand we are saying कि 125 jurisdictions में ये law है और वहाँ पे ये law federally है, should it take over a decade for it to be decided कि ये provincial issue है या ये federal issue है? Should it? It shouldn't have taken that long. So it's our prioritization of economic issues as well. It's a lack of political will and prioritization of economic issues. That was something that needed to be addressed before we talk about implementation effectiveness. ये सबसे अगर आप मेरे 9 साल का एक चीज पूछें कि जी क्यों कंपटीशन लॉ नहीं आया, how do you define effectiveness? Not merely enforcement, because कई लोग ये कहते हैं जी आपने सफेद काले किए ना, आपने इतना फाइन लगा दिया. हम चाहे शुगर को 44 अरब लगाएं या मैंने सेकेंड टर्म में हमने 7 अरब से वो 29 अरब को ले गए हो, हमने यूरिया फर्टिलाइजर को, सीमेंट को, शुगर को, टेलीकॉम को, हर इंपॉर्टेंट सेक्टर में कार्टेल अनवेल किया और एविडेंस दी. अब आप एज एन इंडिविजुअल, whether you're an economist, whether you're an ordinary citizen, whether you're a lawyer, please go through those judgments and decide for yourselves कितना कोई whimsical order है and what is the quality of judgment. बाकी चीजें अलग हो गई. अब पहला जो आप एक बहुत ही इंपॉर्टेंट एस्पेक्ट है, जब आप लैंग्वेज को लोकलाइज कर देंगे, हम वकील हैं, हम हमेशा उसकी डिस्टिंक्शन क्रिएट करेंगे. जब हम बात ही ये कर रहे हैं कि इट इज अबाउट बिहेवियर एंड बिहेवियर अक्रॉस ऑल regimes remains the same, तो कार्टेल्स यहां भी बनते हैं और यूएस में भी बनते हैं. आपकी उनकी फेमिलियरिटी कम होगी. मोनोपोलीज रिस्ट्रिक्टिव ट्रेड ऑर्डिनेंस में ये तो नहीं था ना कि कार्टेल्स के पहले केसेस नहीं हुए थे, सीमेंट के पकड़े नहीं जाते थे. एंड वन थिंग दैट आई आल्सो फील इट वाज इंपॉर्टेंट, क्योंकि बांग्लादेश, इंडिया और पाकिस्तान सारे MRTPO पहला उनका 1969 का लॉ था. What is the difference between that law and this law? Could have also given a better understanding as to where are we coming from. क्योंकि वो mainly prescriptive था, ये normative हो गया. हमने इसको in sync with international principles कर लिया. अब एक concern आता है इस book में. देखिए, there is also recognition and acknowledgement कि अगर आप इंडिया और पाकिस्तान लॉ को substantive इस पे देखें तो लॉ दोनों का इंटरनेशनल इससे इवेंचुअली अब कंप्लाई करता है. इंडिया के भी प्रिंसिपल्स वही थे, उन्होंने लैंग्वेज डिफरेंट रखी, उन्होंने कार्टेल को डिफाइन कर दिया, उन पास एग्जेम्पशन की, एग्रीमेंट्स की प्रोविजन नहीं. ये माइनर और छोटी चीजें. सब्सटैंटिवली इस किताब में मैंने खुद पढ़ा है कि दोनों अगर दिया जाए तो ब्रॉडली ट्रीटी ऑफ रोम और अमेरिका के इस पे पूरे उतरते. हमारा ठीक है, हमारा ट्रीटी ऑफ रोम पे है, लेकिन जैसे डिसेप्टिव मार्केटिंग का सेक्शन है वो तो हमने यूएस से बोरो की है. और जो पाकिस्तान और इंडिया में एक और बड़ा बुनियादी फर्क है, जिसपे बल्कि आई एम वेरी हैप्पी कि फाइनली जो कंपटीशन लॉ की जजमेंट हमारी जस्टिस आयशा मलिक ने लिखी है, उसमें जितनी कॉन्स्टिट्यूशनल इस पे हमारे ग्राउंड्स थे कंपटीशन कमीशन को, उनको अल्हम्दुलिल्लाह वैलिडेशन मिली. एक एक पर्टिकुलर पॉइंट पे शी इज द माइनॉरिटी व्यू एंड देयर आर 2 अदर जजेस इन द बेंच जिन्होंने मेजॉरिटी व्यू होल्ड ये किया है कि अगर वो रिस्ट्रिक्टेड टू वन प्रोविंस है तो प्रोविंशियल गवर्नमेंट भी कंपटीशन लॉ बना सकती है अगर वो बाहर नहीं जाती। नाउ इस पॉइंट को मैं ये गलत और सही की बात नहीं, प्लीज ट्राई टू अंडरस्टैंड थ्योरेटिकली आल्सो, प्रिंसिपली आल्सो, एंड हाउ इट हैज बीन deliberated upon in international jurisprudence. कंपटीशन में 2 चीजें बहुत जरूरी हैं। आप जियोग्राफिकली बाउंड नहीं उसको कर सकते और ट्रेड को आप किसी एक ट्रेड पे नहीं कर सकते बिकॉज आप उसकी क्रॉस सब्सिडी इनटू अदर प्रोडक्ट्स भी दे सकते हैं। इसीलिए वो एक फेडरल एजेंसी ही है जो इसको रेगुलेट कर सकती है और वो सेक्टर स्पेसिफिक रेगुलेटर की डोमेन नहीं है। दिस इज द रीजन इट competition has to be a federal subject। और हमने जो क्लॉज बी ऑफ आर्टिकल 18 ऑफ द कॉन्स्टिट्यूशन है वो जो बोरो किया है वो प्राइमरीली यूएस लॉ के, नॉट यूएस कॉन्स्टिट्यूशन, आई एम टॉकिंग अबाउट यूएस लॉ में इन द इंटरेस्ट ऑफ फ्री ट्रेड एंड कॉमर्स। ये इंडिया के कॉन्स्टिट्यूशन में नहीं है। इंडिया सिंपल मोनोपोली लॉज पे ही साला कुछ बनाता गया है। हमारा जो आइटम 27 है शेड्यूल 2 वो हमने इवेंचुअली हमारा लॉ वैलिडेट तो सारा हुआ ट्रेड एंड कॉमर्स पे। इंटर प्रोविंस ट्रेड एंड कॉमर्स जो रेगुलेटर वो फेडरल कंपटीशन एजेंसी कर सकती। तो ये एस्पेक्ट कॉन्स्टिट्यूशनल चैलेंजेस, इम्प्लीमेंटेशन, ट्राइब्यूनल बीइंग मेड, not being members not being appointed in the competition agency, ये क्या बात हुई कि मैंने अभी जुलाई में जब टर्म खत्म की for 6 months I was the sole one woman commission। उससे मार्च लास्ट 2022 में दो मेंबर्स चले गए और हम 2 मेंबर्स पे काम करते रहे। हमने 2 मेंबर्स के डिस्पाइट के वी वर 2 मेंबर्स, हमने 8 सर्च एंड इंस्पेक्शंस कंडक्ट की जो कि हमारे डेलीगेटेड पावर्स अलाउ करते थे। हमारे एक मेंबर एससीसीपी में चले जाते हैं और 6 महीना अपॉइंटमेंट नहीं होती है, एंड soon as I leave 4 मेंबर्स अपॉइंट हो जाते। So when you are actually keeping the organization, you are disabling an organization to perform a function, what does it reflect? Lack of political will. So strengthening of institutions में एक खुद regulatory body जो main function discharge कर रही है, the quality of people it comprises and its smooth functioning and appointment is it plays a very critical role। आपने ट्राइब्यूनल बना दिया, ट्राइब्यूनल हमारे कहने पे बना था क्योंकि we were made to run from pillar to post all provinces, so many writ petitions files। अगर मैं आपसे सिर्फ एक केस की डिटेल शेयर करूं तो आपको 2 घंटे लगेंगे सुनने में। The kind of it drains you to enforce competition law against vested interests। It's not easy। So the thing to be appreciated is not alone आप disagree कर सकते हैं jurisprudence से, आप disagree कर सकते हैं बहुत सारी चीजों से, आप hardcore evidence देखें, आप remedy देखें, आप ये देखें कि enforcement किन के against की गई है। How do you evaluate the independence of an agency? How do you evaluate an independence of an agency? It speaks through its decisions। आपने फेयरली fearlessly किन किन इदारों के अगेंस्ट, किन किन कंपनीज के अगेंस्ट काम किया है, दैट इज इंपॉर्टेंट। सो मेरा पर्सपेक्टिव सिर्फ ये है कि हम इसको, जाहिर है देयर इज नो एम्पिरिकल एविडेंस कि जी ये इससे प्रूव नहीं हो रहा और सो रहा है। मुझे लगता है कि इसमें इनकंसिस्टेंसीज अराइज हो जाएंगी एंड अभी वी हैव नॉट रीच्ड दैट। वो सॉरी मैं डोनाल्ड रोजलिंड का जो 2010 का आर्टिकल था जिसमें एसएससीपी को एज अ सक्सेस स्टोरी टर्म किया गया था, उसमें उन्होंने कहा कि इट्स अ डिसेप्टिव टाइटल, the hare and the tortoise, when neither of us are hare or tortoise, we are each discharging our functions at best as we can and time will tell what will happen। So अब 2010 से 2012 में हम आ जाते, वो 2010 में आया, उस वक्त तो हमें सक्सेस स्टोरी कहा गया, इंडिया सक्सेस स्टोरी नहीं था, इट हैड जस्ट स्टार्टेड। अब इन इतने सालों में इंडिया ने बहुत अच्छे काम किए, इसमें कोई शक नहीं, कुछ डिसीजंस बहुत अच्छे। That does not make one agency lesser than the other because our set of challenges remain very different। आप जब एक और एस्पेक्ट है जब आप ये कहती हैं कि हम लाइक अ पुलिस, ठीक है, I don't disagree, yes it is, it's a quasi judicial, quasi-regulatory law enforcement agency. लेकिन not just when it happens we come into play. क्योंकि जो merger का part है, वो regulatory है, ठीक है? It is not only when it happens that we have to take it, it's a so say ex ante and ex post. जो एक्ट से पहले है, जो रेगुलेशन का हिस्सा है, जनरली वो सेक्टर स्पेसिफिक रेगुलेटर्स करते हैं, जो लाइसेंसिंग एंड अदर थिंग्स. बट मर्जर में सिर्फ एक सिंपल सी एग्जांपल देती हूँ अबाउट द सिग्निफिकेंस ऑफ इट, कि around 90 to 95% of merger applications that come to competition agencies have no competition issue. Yet they come. Why do they come? Pakistan is a mandatory regime. They come because undoing a merger is a huge task. So you regulate that side. So ye hamari regulatory side is more on exemptions and mergers. The enforcement side is cartel, trade abuse, and deceptive marketing practices. That's how we have divided it. I really hope कि इसमें एक insight add हो सकती है. And I'm sure since Dr. Amber is working on it, and this is a subject that she teaches, it will interest her to see in various regimes how the institution has performed and not performed and what have been the challenge. Continuous challenge is, if I can say it with quite some certainty, when there is no political will and then there is no prioritization on economic issues, nothing really helps. अब मुझसे ये कहा जाता है कि जी आपके तो जो फाइन्स हैं और पेनल्टीज हैं वो रिकवर ही नहीं होते, तो आया कितना? तो इसके लिए how can you hold a competition agency accountable? We can see the difference when you see Federation proactively standing with us and arguing the constitutional violations. You get the result. Otherwise, just to share, हमारा matter 2009 से onwards 7-8 times it has been reheard on this single issue कि फेडरल है या प्रोविंशियल होना चाहिए. और 125 में से मतलब एक था जहां पे तो सारे प्रोविंसेस ने लिखकर इसकी कंसेंसस थी और दे दिया था कि फेडरेशन ही कर सकती है, तो उन्होंने दे दिया. तो इस बैकग्राउंड के साथ can only a competition agency be held accountable? Now, I think there are other aspects to effectiveness that I don't want to delve too much into it. One aspect that is important is some of the judgments that have been referred to. Now, for instance, इनके preface में ही है, और क्योंकि forgive me because cement, I'm the author of the cement thing along with Khalid Mirza, तो उसमें उन्होंने लिखा है कि जी आपने 1/3 of the order only talks about constitutional violations and without deciding anything on it, आप ने सारा ऑर्डर उस पर लिख दिया. मेरी आपसे दरखास्त है छोटी सी, प्लीज वो ऑर्डर पढ़ लें 75 पेज का. उसमें कॉन्स्टिट्यूशनल वायरीज 2 या 2.5 सफे पे लिखी गई है और सुप्रीम कोर्ट की जो जजमेंट्स थी डिफरेंट, परवेज अख्तर और मैरमल केस एंड बाकी, उसमें हमने रिलाय करते हुए सिर्फ ये कहा था कि जब कॉन्स्टिट्यूशनल वायरीज होती है तो एक रेगुलेटरी बॉडी ये डिसाइड नहीं कर सकती, ये कोर्ट ही करेगा. तो जितने भी पिटिशनर्स थे वो तो खैर शी वाज नॉट एट दैट टाइम द लॉयर बिफोर अस, बट आई एम जस्ट सेइंग कॉन्स्टिट्यूशनल इश्यूज हमने बिल्कुल मुनासिब अंदाज से समराइज करके इस चीज पे डिस्पोज किए थे कि वी आर नॉट कॉम्पिटेंट टू डू इट. लीगल ऑब्जेक्शंस हैव बीन डिसाइडेड, बट केस था क्या? व्हाट वाज द केस? कोटा एलोकेशन हो रही थी, हार्ड कोर एग्रीमेंट मिला था 2008 का, चार्टर्ड अकाउंटेंट उसको लिए पेड था और मॉनिटर कर रहा था कि कोटा एलोकेशन कैसे होती है और कैपेसिटी एनहांस नहीं होती. इसकी एविडेंस मिल गई. दिस इज यूनिक. एंड देयर इज वन क्रिटिसिज्म कि जी कंपटीशन एजेंसी हैज नॉट टेकन इनटू अकाउंट कि पेनल्टी की क्या रैशनलाइजेशन है. पहली बार 2009 में फाइनिंग गाइडलाइंस आई थी कंपटीशन की, और अगर आप लास्ट 10 पेजेस पढ़ें तो दुनिया में कितने फाइन लगे हैं इस पे, और हम क्यों रिस्ट्रिक्ट कर रहे हैं 7.5% ऑफ द टर्नओवर तक. उसकी रीजनिंग मिलेगी आपको. 1.4 बिलियन यूरोज लगा था, हमने तो 6.25 अरब लगाया था, जिससे उन्होंने कहा कि जी हाइटस हो गया और पूरी इट रॉक्ड द बिजनेस कम्युनिटी. Do you think these vested people with vested interests will ever welcome enforcement of competition law? Please try to understand. Okay, obviously, they are businesses. They are doing it for profit. We have nothing against them if they make profit, but collusion is a serious offense. It has turned our economy into a reeling economy. We are bleeding because of these vested interests not letting the competition flow in. जब आप competition के benefits की बात करती हैं ना, obviously very standard इसमें एक चीज बहुत जरूरी है, is the foreign investment. Competition makes you globally competitive. आपके यहाँ इन्वेस्टमेंट नहीं आएगी आपकी अगर कंपटीशन अथॉरिटी नहीं है और वो इफेक्टिव नहीं है. फॉरेन डायरेक्ट इन्वेस्टमेंट इज वन ऑफ द मेजर कंसिडरेशंस. तो आप and if there is no competition, can you really think कि हम अपनी 1.5 ईंट की मस्जिद बना करके ग्लोबली कंपेटिटिव रहेंगे? ठीक है. सो इंटरनेशनल इसमें अगर आप उन प्रेसिडेंट्स को फॉलो करते हैं तो हर किस इसका मकसद ये नहीं है कि आपने सब्सटैंटिव रीजंस के लिए नहीं किया, बल्कि आपने सिर्फ एक स्टैंडर्ड को कंप्लाई करने के लिए टिक बॉक्स किया. इट हैज लॉट ऑफ विजडम टू ऑफर एंड पाकिस्तान हैड द एडवांटेज ऑफ एज अ लेट मूवर एडवांटेज हम इसको कहते हैं कि हमने EU, US और डिफरेंट जिनकी जूरिस्प्रूडेंस थी उसको लॉ में किया. आई थिंक कॉम्पिटिशन एक्ट is a wonderful thing. दो चीजें सिर्फ लास्ट में, I think the time is running short. Sorry, I am this competition law is something I passionately feel. लेकिन दो चीजें बहुत बहुत important. Competition law, competition act इंडिया का जितना भी अच्छा हो और लोकल हो, उन्होंने अपनी लोकल उसमें एक चीज दिखाई. They can supersede the commission and suspend it for 6 months. हमारी ऐसी कोई नहीं है provision. Alhamdulillah. और despite के the federal government can give directive, जो कि इंडिया के इसमें भी है, it cannot be inconsistent with the act. Not one sector has been given exemption since the time of its inception. Banks ने लेने की कोशिश की, Securities and Exchange Commission वालों को stock exchanges ने लेने की कोशिश की, telecom ने लेने की कोशिश की. We had to struggle for it. Banks are a jugular vein. हम उनको कहते हैं हाँ जी स्टेट बैंक आपको रेगुलेट करते हैं, आप इकोनॉमी से निकल जाओ. सो ये एक लीगल फ्रेमवर्क की स्ट्रेंथ थी जिसके बेसिस पे फेडरल गवर्नमेंट इसको नहीं दे सकती थी. ये बहुत इंपॉर्टेंट प्रोविजन है. वहां पे तो सस्पेंड हो सकता है, हुआ नहीं है लेकिन हो सकता है. दैट इज वन इंपॉर्टेंट डिफेक्ट in that law, I believe. Secondly, the most creative provision in the Competition Act of Pakistan is its financial autonomy, alhamdulillah, which I was able to achieve with my team in the last term. 3% of the fee and charges have to be given by other regulators. Legislative wisdom mein to ye 2007 mein aa gaya. Why is it that now we were able to implement in 2020? Because at that time there was political will. पहले नहीं थी. पता है ये क्या बात हुई कि एक जो अप्रूव्ड प्रोविजन है एक्ट की उसको मुझे इंप्लीमेंट करने में 13 साल लग गए. और आप ये सोचें कि आप हर दफा लेकर के जब आप जाते हैं पैसों के लिए, 6 साल तक कमीशन हैड ओनली 200 million rupees that it was being given. ये हमने अचीव फाइनेंशियल ऑटोनॉमी अब की है लास्ट 3 years में. लॉ पास हमने 2010 के बाद किया था. पीक इन्फोर्समेंट 2020 से 2023 में और 2007 से लेकर 2013 तक हुई है. और आप ये जो बात करती हैं कि जी वो हॉल्ट आ गया तो एडवोकेसी शुरू कर दी, दैट इज व्हाट आई थिंक इज अ चेंज ऑफ पर्सपेक्टिव एंड लीडरशिप. इन्फोर्समेंट इज नॉट अ चॉइस, इट इज अ मस्ट. जहां पे आप इन्फोर्समेंट को एक चॉइस बना के लेंगे, यू आर नॉट डिस्चार्जिंग योर फंक्शन. थैंक यू.
Thank you so much, Mr. Rahat. Appreciate it. I think it's safe to say that you have a slightly different perspective to Dr. Darr on this, and I'm sure we'll get into that. I want to move to questions and answers, but just before that, I'd like to give Dr. Darr maybe like 5 to 10 minutes or so just to respond to some of the things that Mr. Rahat has brought up.
And would you just let me know the time? I don't want to go over, and I actually don't want to over respond.
Just 5 to 10 minutes, then we'll
yeah, you give me a timeout.
Okay.
So सबसे पहले तो thank you very much for your comments. हमारे यहाँ कहा जाता है कि किसी भी communication की value उतनी होती है जितना दूसरे को समझ आ जाए. तो I think today I've understood how much she got out of my books, and I'm very grateful for reading it. कुछ बातें आपने कहीं which I just want to clarify. आपने कहा डेटा कभी मांगा नहीं गया. डेटा मैंने actually मांगा था और मुझे officially दिया गया था by Ikramul Haq, who used to be the deputy, and I have all the resources, and of course I have references. You were very kind to give a very long interview, and I appreciate that very much. Kuch, I think there was some, I feel maybe I've not communicated myself clearly. Aapne pucha ke December, sorry, it's not clear in the book whether the cases I referred to were till June or December 2020. They were till December 2020. I think this should be clear in the book. I'm sorry if it isn't. IHC ki judgment, Lahore High Court judgment has been referenced several times. I have mentioned that more than 92 appeals have now been decided. So this issue is now evolving, but ye sab pending hai appeal in the Supreme Court, so we don't have final decisions. You can correct me, of course. I did my due diligence, and mujhe pata chala tha ki abhi aap log appeals ka wait kar rahe hain, you have not recovered any of the fines. Jo main point I also want to raise, and I feel this was a misunderstanding, perhaps again I take full responsibility if I have not communicated that clearly, ki this was not a test of whether India is better or Pakistan is better. At least never for me. This was not set up as a test. And I hope that in my presentation, I made that clear. That people can start, countries can start at different points. One looks better, the other may not look so good, but they end up, it's a gray area. हमने किसी को भी winner or loser के तौर पे नहीं portray करना था, but to show that different strategies result in different outcomes, और हम कैसे अपनी strategies को बेहतर बना सकते हैं to achieve better outcomes. You're very rightly upset that आपने political will आपके साथ नहीं थी. I think इससे ज़्यादा, मुझसे ज़्यादा तो इस बात को कोई नहीं समझता है, because I was here and in those days, in those years, and you of course also have talked about it. This is mentioned again and again in the book. I'm sorry that it could not have been more clearly mentioned. Tribunal ki formation mein political, maybe the phrase political will has not been used, but I talk in more than one occasion about the troubles that the Competition Commission faced, because inka law ordinance ke तहत आया था और 4 बार ordinance बनी, जबकि इनको finally जाके act मिला, और उससे कितनी uncertainty और problems create हुई. I talk about the fact that tribunal को कभी भी वो support नहीं मिली. बहुत ज़्यादा emphasis है government की lack of support पे. Yes, perhaps the phrase political will has not been used, but I am working with a certain literature. मैं उसकी language और उसके framework में रहकर language use कर रही हूँ. So maybe the phrase political will has not been used, but I think it is absolutely clear to me, and I am concerned that this was not communicated clearly to you, that this was a very, very important point. You mentioned that you somehow, at least I got the sense कि आपको लगा कि शायद I was criticizing the CCP for relying on foreign precedents. No, I was not. Everybody relies on foreign precedents. As you have rightly said, this is an international law. Competition है ही एक international model. आप जब उसको interpret करेंगे, आप foreign precedents को rely करेंगे. Point ये था कि आप उनको किस, जो मैंने पढ़ा जितनी judgments, बहुत सी judgments, early judgments में, Competition Commission अपने orders को शुरू ही इस बात से करती थी कि we derive our we are based on the European Treaty of Europe के articles 82 and 81 and 82. एक बड़ी overt किस्म की उसकी एक claim करती थी international legitimacy, जो कि और orders में missing थी. The citing was overt. I also say in my charts कि ये फिर खत्म हो गया. And I think if I have not mapped the years to chairpersons, but I'm sure that around the time that Ms. Kaunain Hassan was the chairperson, ये reliance बहुत कम होती गई, and then the reliance became on CCP's own orders. So again, this was not meant as a criticism. It is something I stand by even right now. It is meant to display, to reveal the evolution of the law and how it goes from being a foreign transplant to something that has been adopted, accepted, understood, and utilized. So in fact, I was telling a success story in my view. So I'm concerned that did not come down. दूसरी फिर आपने एक point raise किया कि top. That, I mean, I'm not sure of the percentages. I think you have read the book more recently than I have. I read it. Yeah, that's fine. That's fine. It's funny when you write a book, you never want to read it again. So मैंने तो अब नहीं पढ़ी है बहुत दिनों से, but of course you've read it. उसमें जो again, that's a very important point to pick up, because again, nowhere am I saying, and I think मैंने अपनी presentation में भी ये बात कही है, so I hope I've communicated to you clearly today that it's not कि आप top down करेंगे तो आप unsuccessful होंगे, आप bottom up करेंगे तो आप successful होंगे. In fact, it is the mix. ये जो countries थे, श्रीलंका, नेपाल, और I don't remember Bangladesh now, but Sri Lanka and Nepal, I can definitely remember what happened over there. उन्होंने कहने को तो एक certain procedure से किया, लेकिन उनकी strategy बिल्कुल different थी. So in fact, the answer is कि it is the mix of institution and strategy that makes a difference. It is not just the top down or bottom up. Pakistan, I have also, you talked about foreign direct investment. I have definitely talked about that. In fact, introduction of foreign direct investment, so the countries adopted these laws to attract foreign direct investment and to make themselves more attractive to foreign countries. Uber ka jo case tha, which is the only merger case I cite, in fact, the case was decided because they said, hum Uber ke khilaf kuch nahi kar sakte because this is foreign direct investment, and that's fine. That's fine. That's a policy decision for the government, for the authority to make. I mean, I don't criticize it. I think what is difficult perhaps to appreciate for everybody is that I am not criticizing anyone, and I'm not holding up anyone as a winner and anybody else as a loser. It is a comparative analysis which says where countries stand on the spectrum of adoption and enforcement of competition laws. Regional model की आप बात करती हैं, I really appreciate कि अच्छा लगता अगर मैं बनाती, मगर फिर वही एक top down बात हो जाती कि कोई बाहर से बैठ के मॉडल बना रहा है. Real models and laws should only be constructed with, बहुत से मॉडल्स एग्जिस्ट करते हैं. हमारी तो रीजनल इकोनॉमिक पॉपुलेशन डाइवर्सिटी इतनी ज्यादा है हमारे रीजन में कि एक लॉ तो हमारे लिए ठीक नहीं है. अंकटाड का मॉडल लॉ है, वर्ल्ड बैंक का मॉडल लॉ है, यूएस के मॉडल लॉज हैं, ईयू के हर मुल्क का मॉडल लॉ है. व्हाट इज इंपॉर्टेंट इज नॉट अ मॉडल लॉ बट the appropriate adaptation of the law for our context. आप प्रिंसिपल्स को किसी मुल्क ने नहीं अडैप्ट किया है. अगर कार्टेल ग्वाटेमाला में भी कार्टेल है, इंडिया में भी कार्टेल है, पाकिस्तान में भी कार्टेल है, लेकिन उसके कौन से इंस्टीट्यूशंस हैं, कौन से टेस्ट्स हैं, कितने उनको स्पेसिफाई करना है, क्या कंपोजिशन होगी, कौन लोग बैठेंगे उसकी जजमेंट में, दोज आर द थिंग्स वी नीड टू अडैप्ट. आपने बात की कि आपने कहा कि आपके पास मेंबर्स नहीं थे, जिसका आई एम वेरी सॉरी टू हियर दैट मेड मी वेरी सैड कि हमारे कंपटीशन कमीशन, आई एम सॉरी आई डिडंट नो दैट एक्चुअली, बट मुझे बहुत दुख होता है जब मैं देखती हूँ कि हमारी गवर्नमेंट कितना हमारे इंस्टीट्यूशंस को शॉर्ट चेंज करती है. इस पे बहुत बात हुई है बुक में. देयर इज अ होल पैरामीटर ऑन composition of authorities, how people are appointed, how people are removed. पाकिस्तान ने मैंने बल्कि पाकिस्तान के और भी regulatory laws को देखा. I feel one of this didn't come up in my presentation, but to me it's a very important point कि हमारे NEPRA, OGRA, PEMRA, SECP शायद, I think there were 6 or 7 regulatory laws. Laws बहुत अच्छे लिखे हुए हैं, language भी जबरदस्त है, European standards पे fit आती है. सिर्फ एक provision है जो हम अपने लिए रख लेते हैं. By hum, I mean the government of Pakistan. और वो provision है, people, and I'm paraphrasing, not quoting, कि हम अपनी मर्जी से लोगों को अपॉइंट करेंगे और निकालेंगे. उस एक provision से सारे law का सत्यानाश हो जाता है. That is the biggest tragedy. So, I mean, I am sorry that I didn't come across more forcefully against the government, but अगर कोई villain है यहाँ पर, तो वाकई governments हैं. Governments, the way they set up the deliberation process, India ने एक राघवान कमेटी बनाई जो फ्रॉम 1999 टू 2001 उन्होंने कोई 80 मॉडल्स पढ़े, ऑर्डिनरी लोगों ने पढ़े. अगर कल हम एक कमीशन बनाए, व्हाई शुडंट राहत कौनैन हसन चेयर इट? Because who knows more about competition law than she does at this point in Pakistan? I certainly don't. I'm not claiming that. मुझे South Asia का पता है. I'm talking about a different perspective. हम नहीं अच्छे लोगों को लाते. हमने क्यों सिर्फ वर्ल्ड बैंक के लीडर्स को वो जाके वो आ गए यहाँ पे, मे बी 1 साल रहे, 6 महीने रहे, उन्होंने ओवर 6 months 2 मीटिंग्स की. मैंने सर तोड़ कोशिश लगा ली कि मुझे कहीं से उन मीटिंग्स के मिनट्स मिल जाएं, नहीं मिले मुझे. इन द मेन्स रिपोर्ट, एरिक मेन्स की रिपोर्ट थी जो वर्ल्ड बैंक के जो ऑफिसर थे जिन्होंने इशू की थी, उसके फुटनोट में, उसके एक्नॉलेजमेंट सेक्शन में, वी आर ग्रेटफुल टू 2 meetings were held in PC Lahore and such. That's how I found out there were meetings held. I know they privately met people because they privately met SECP as well. I used to be what was I? Executive Director Law at the SECP when I was working here. तो वो हमसे भी मिलने आए थे. लेकिन that's not the way you consult. There were no broad-based consultations. उसका बहुत नुकसान होता है। इनको बहुत अपने, ये बिल्कुल सही कह रही हैं कि इनको जो तगोदौ करनी पड़ी अपने आप को लेजिटिमाइज करवाने के लिए, दैट्स द वर्ड, she as a single lone chairperson had to, and as a member legal, had to strive hard to gain legitimacy. So I feel, I'm just going to end with that. I'm only going to say we are more in agreement than I have been able to communicate. And I hope there will be a second reading of the book, and then the agreement will become more evident. But I certainly don't see any points of disagreement. But thank you very much, Abbas.
Thanks so much, Dr. Darr. Okay, so I had a few questions of my own, but in the interest of time, we only have about 15 minutes left. So if anyone in the audience would like to ask any questions, whether that's online or over here, please feel free. Just introduce yourself.
अस्सलामुअलैकुम। मैं काफी अरसे से आपको देखा है चेयरमैन, लेकिन इतना पैशन के साथ पहली दफा देखा है। पहले कभी
ये किताब की खासियत है।
So, आपने इतनी बड़े बड़े सेक्टर्स का मुकाबला किया, प्राइवेट सेक्टर का, गवर्नमेंट का, एक औरत होके, तो आप ये जितने रेयर, ये जो आप सारे केसेस हैं, किसी आप यूनिवर्सिटी में पढ़ाएं तो मैं पढ़ना चाहूँगा। और मैरम अली केस के जो कॉन्स्टिट्यूशनल प्रिंसिपल्स आपने किस तरह उसका जवाब दिया है, वो आप मुझे बता दें।
Sorry, can I give you back the... नहीं, I think it doesn't come up.
सॉरी, ये जो मैंने मैरम अली का था, पीर साबिर शाह का केस था जिसपे हमने रिलाई किया था, और अख्तर परवेज का जिसपे हमने रिलाई किया था। उससे प्राइमरीली ये कहा था कि अख्तर परवेज का जो जजमेंट थी जिसपे पीर साबिर शाह ने भी एक्नॉलेज किया था, वो ये था कि जब कॉन्स्टिट्यूशनल वायरीज होंगी लॉ की, तो वो एक organization as a regulatory body like us and an administrative tribunal cannot decide. It will go to the court. लेकिन अगर ये डिसाइड करना होगा कि हमारी ये जुरिस्डिक्शन में फॉल करता है या नहीं करता, तो हम वो इश्यूज रिजॉल्व कर सकते हैं। तो सिमन केस में जितनी कॉन्स्टिट्यूशनल इश्यूज हुए थे वो हमने सम अप कर दिए, और हमने उस पे on the basis of the local precedents and the Supreme Court citations, we just said we restrain from deciding these matters, and we would go on the other aspects. तो हमने legal objections सारी की। अच्छा, cement case का maybe you would be interested in understanding more than what goes behind the scenes as well. It was the first case of our search and inspection and exercising forcible entry. फोर्सिबल एंट्री हमारे सारे रेगुलेटर्स के पास है। मैं तो बड़े उससे चैलेंज करती हूँ कि मुझे बताएं कितने इदारे हैं जिन्होंने सर्च एंड इंस्पेक्शंस किए हैं और फोर्सिबल एंट्रीज जो हैं वो कैरी आउट की हैं। इट रिक्वायर्स लॉट ऑफ करेज, it requires a lot of compliance requirements with it. Or why is it that in cement cartel case, in a sugar case, in practice case, जितने आपके बड़े-बड़े cartels हैं, इनको ही हमारे search and inspection powers पे सबसे ज्यादा इतराज होता है। अगर आप देखिए, वो कहते हैं, इनकी प्रपोजल आई थी पार्लियामेंट में कि जी मैजिस्ट्रेट से वारंट लेके आना चाहिए, तो फिर मैं इश्तिहार ही ना दे दूं कि मैं छापा मारने जा रही हूँ। मतलब अगर हमने मैजिस्ट्रेट से लेना है, मैंने अपने एज अ मेंबर लीगल 12 जुरिस्डिक्शन से कंपैरेटिव टेबल बनाया था कि हमारे जो पावर्स हैं दे आर वेरी मच इन सिंक विद ऑल डेवलप्ड जुरिस्डिक्शंस। हम अफोर्ड ही नहीं कर सकते कि हम जाकर के पहले वारंट लें और फिर छापे का ऐलान करें। Just in the last 3 years, we conducted 24 search and inspections. That's not ordinary. आपको पता है जो ग्लोबल कंपटीशन रिव्यू है वो आपके इन्फोर्समेंट पावर्स में जो चीज देखती है, आपने पेनल्टी कितनी लगाई और आपने छापे कितने मारे, तो आपका इन्फोर्समेंट फोकस होता है। ये ब्रॉडर पैरामीटर्स हैं। ऑब्वियसली आपका डिसीजन भी होता है, जो डिसीजन इनकी ऑब्वियसली डोमेन में नहीं आता, लेकिन मैं क्योंकि इट्स वन ऑफ द मोस्ट डिफिकल्ट डिसीजंस, इट इज, आई थिंक इट्स हिस्टोरिकली समथिंग वेरी रेलेवेंट, इज अबाउट द शुगर कार्टेल। शुगर कार्टेल का केस किसे नहीं पता, जीआईटी की रिपोर्ट आ गई, हमारी इंक्वायरी ऑलरेडी चल रही थी, हमने जब देखा कि इतने इश्यूज आ रहे हैं तो हमने अपनी टीओआर's रिवाइज की इन लाइट ऑफ द रेलेवेंट इश्यूज। हमने वो इंक्वायरी कंप्लीट की, हमने ऑर्डर पास किया पूरे कमीशन में। दिस इज an order which is historically very relevant because it imposed the highest penalty of around 44 billion on 82 sugar mills, right? And mashallah say a battalion of lawyers were appearing, and very high profile lawyers, very competent lawyers. And we, the small commission, had to actually pass a judgment on it. और केस क्या? दो बुनियादी केसेस देखे इसमें क्या थे? एक वो ये कर रहे थे कि सेंसिटिव इंफॉर्मेशन शेयरिंग कर रहे. आपको पता है कि शुगर में आपका 12 महीने में से आपके 3 महीने क्रशिंग होती, बाकी तो स्टॉक्स पे चलता है. तो इंफॉर्मेशन रिलेटिंग टू स्टॉक्स वाज बीइंग शेयर्ड.
Mr. Rahat, we're just going to take one more round.
I'll just, please, this is important.
Okay.
See, if you'll just go by the time, then
Sure.
I can stop right now. Why I think it's important is that they need to read those decisions.
Sure.
So usme humne casting vote kiya, and there was a decision. The two people were divided. So I exercised the first time ever a casting vote in the commission. Ab सारा केस इस पे चलेगा कि कास्टिंग वोट गलत हुआ या सही हुआ, कार्टेल रह जाएगा. लेकिन मेरा सवाल सिर्फ ये है, अगर मैंने वोट कास्ट ना किया होता इन द इंटरेस्ट पब्लिक, तो आज वो डेड डिसीजन होता. It would not have gone for judicial review. Try to understand the relevance. As a regulator, I had to do this and exercise it in the fiduciary position that I was holding, and also in light of the law, it empowered me. तो ये इस तरह की चीजें हम उस पर डिबेट ही नहीं करते. We're running short of time. I'll stop there.
Thank you so much. Does anyone else have any questions? We'll take a round. एक दो ले लेते हैं. And if there's anyone who has joined us online who would like to ask a question, please just raise your hand.
Assalamu alaikum. This is Hamza from Ali Raza and Partners. I'm a practicing lawyer. Amber, I haven't read your book, and I've had the experience of a few competition cases in Pakistan. Did you ever take into account certain provisions of certain laws in Pakistan, which actually do cater for competition apart from the Competition Act? For instance, the PTRA, the Pakistan Telecommunication Regulatory Reorganization Act. It has a certain provision which says the PTA shall have the power to regulate competition between its licensees. So it's a provision which is independent and separate and works in isolation. It has nothing to do with the Competition Act. Actually, that law came out in 1996, whereas the Competition Act came much later. So there were certain laws which did cater or actually were used to regulate competition between certain licensees or certain companies, but that was that empowered the relevant regulator, in this instance, the PTA. And there is one case which is currently pending before the Islamabad High Court, wherein the question is whether the PTA has the power to regulate competition between the licensees such as Mobilink, Jazz, and Telenor, CM Park, or the Competition Commission. So there's a conflict in provisions, a general law, special law. Those questions have been raised in that case. And don't you believe such cases also raise the question of legitimacy and effectiveness? Because in that case, the CCP had issued certain notices to the telecom companies. And the telecom companies challenged those notices before the Islamabad High Court, saying that we have a specific regulator and there's a specific provision in specific law under who we are the licensees. And therefore, the CCP does not have the jurisdiction. And that also affects the effectiveness of their jurisdiction and how they want to treat the issue. What are your views on that?
Okay, that's a great question. But shall we take, if there's another question, but I think that's an important issue. Any other questions?
No questions.
No. So we can have a slightly longer, like 2-minute answer. So the book doesn't talk about this. Okay. So the book is, because they can, unfortunately, I could spend the rest of my life writing many more books on this issue, but I actually don't plan to. I'm moving on to other issues. So the book is on a different issue, which is about the actual specific competition laws, joke, cartels, anti-competitive agreements, abuse of dominance, mergers, एक specific package आता है उसको deal करें. जो आप बात कर रहे हैं वो बहुत अहम है, and उस पर बहुत research हुई भी है, which is the demarcation between sector regulators and competition regulators. My understanding is twofold.
फर्स्ट ऑफ ऑल ये जो पीटीसी ये काफी लॉज में है, ये पीटीसीएल के में भी था ना, आप पीटीसीएल की नहीं बात कर रहे, आप तो किसी और लॉ की पीटीआर, तो पीटीसीएल में भी ऐसा है कि सिग्निफिकेंट मार्केट पावर की भी बात की गई है एंड ऑल ऑफ दैट. नाउ व्हाट्स इंटरेस्टिंग अबाउट दोज लॉज कि वो कंपटीशन का लफ्ज जरूर यूज कर रहे हैं, लेकिन वो उसका क्राइटेरिया वो यूज नहीं कर रहे जो कंपटीशन कमीशन, जो कंपटीशन एक्ट बात कर रहा है. और कंपटीशन एक्ट की तरह उनका ग्लोबल व्यू भी नहीं है कि इकोनॉमिक स्ट्रक्चर और रेलेवेंट मार्केट में वो किस तरह एक्ट करेंगे. सो आई थिंक कंपटीशन commission being the apex competition regulator cannot be ousted from sectors. That is my understanding. It's बहुत research हुई है, and I think I mean there are articles can be found. Special general वाली बात चलेगी. Competition law is special in a particular sense because it specifies particular criteria. So I think that the issue here will be what exactly is the problem? What is the abuse that is taking place? And if it is the abuse, or I use the word abuse loosely, if it's a violation of the Competition Act rather than the word competition, which is undefined, unspecified, not undefined but unspecified, does it have the same criteria? What are they really evaluating in competition? That's where the difference will take place. But usually concurrent hai, dono ki powers. Competition Commission cannot be ousted, as far as I understand. Rahat may be able to point out to it.
Yeah, एक तो इस केस के शायद फैक्ट्स थोड़े पर्टिकुलर हैं. आई एम राइट नाउ नॉट रिकॉलिंग इट, बट इस केस में व्हाट यू नीड टू सी इज कि क्या उनकी लाइसेंसिंग रिजीम की कोई कंडीशन थी दैट दे कुड हैव एड्रेस्ड, और कंपटीशन कमीशन प्रीमेच्योरली आ गया बिफोर दैट. बट आई एग्री विद व्हाट अंबर सेड दैट you have to eventually see, firstly, a regulation cannot just make KB competition issues will fall within our thing, because we are, overarching law hai, parliament ki legislative wisdom thi ke wo act ke through aaye. Dusra, bahut rightly, as she has pointed out, ki contravention and competition offenses are to be looked after by a federal agency, which is not a sector specific regulator. So this has to be, matlab, agar wo case contravention से डील करता है और offenses से डील करता है तो competition इसमें आएगा. अगर PTA एक्ट की वायलेशन है और किसी रेगुलेशन से नॉन कंप्लायंस है तो उनके इसमें आएगा. इसमें अगर थोड़ा सा और क्लैरिटी ऐड हो जाएगी, अगर आप डिसेप्टिव मार्केटिंग का सेक्शन 10 देखेंगे ना, तो हमारे 12 लॉज से ओवरलैप करता है, ठीक है, including the IPO laws. लेकिन उसमें भी we complement, because when you say they are contradictory of each other, that means they cannot stand together. Where they can stand together, then it's a different way you deal with it. Then you see कि किसकी domain पहले special कौन है और general कौन है, और फिर special law तो competition पे competition commission ही होगा.
Exactly. एक छोटी सी मुझे observation है. I have a bad feeling that you're for the side that is arguing कि competition law नहीं apply करता.
You have disclosed.
I get that vibe. But you can you're not working. Yeah, but it's I will say कि अगर इस पे कोई पाकिस्तान के context में इस specific चीज पे काम नहीं हुआ है, okay, होना चाहिए. I think, see, one of the things I love is now research. I used to love being a lawyer, but now I love research, and I think कि हर चीज में आप deeper जा सकते हैं. So I think if this is something that interests you, it is definitely worth investigating, and there are avenues for publishing things like this. So I'll be happy to help if this is something that you.
वैसे इसमें आप कंपटीशन कमीशन का पाकिस्तान स्टॉक एक्सचेंज का ऑर्डर देख लीजिएगा अब्यूज ऑफ डोमिनेंस में, क्योंकि उन्होंने भी यही लिया था कि सिक्योरिटीज लॉज करते हैं और कंपटीशन नहीं करते.
उनके अगर डिसीजंस को आप कॉन्टेक्चुअलाइज करें इन ग्लोबल, ये ग्लोबली अग्रीड पोजीशन है. इसमें आई थिंक दिस इज एब्सोल्युटली द रिसीव्ड पोजीशन, बट इट्स वेरी इंटरेस्टिंग टू गो एंड सी. लेकिन हम बहुत सी चीजों को मिसअंडरस्टैंड कर जाते हैं जब उन्हें पाकिस्तान स्पेसिफिक देखते हैं. I think you can go out and see actually this is how it is. This law is it has a very specific and very important purpose. As I mentioned in my earlier slides, for maintaining economic efficiency in the country, आपकी allocation वो global perspective कोई दे नहीं सकता. और ठीक है, और इसकी offenses भी बड़े specific हैं. As a lecturer, it is so easy for me to teach this subject because मैं अपने students को इस तरह बतलाती हूँ, मैं कहती हूँ सिर्फ 3 offenses हैं, आ जाएं, वो खुश हो जाते हैं, सिर्फ 3 बातें पढ़नी पड़ेंगी, and then we go into depth. But there are really 3 or 4 in Pakistan's case, 4 major areas. So, yeah.
Sorry, 2 minutes I'll take. I know this is because there was this point being discussed that only when the act happens, that is where the competition law comes into action. I just want to say that competition law में 3 schemes हैं. One है enforcement, one है advocacy, एक है policy notes. and public hearing. So policy इसमें legal frameworks जब bills आते हैं तो ideally जो committees उसको review करती हैं, that should be sent, because otherwise we take it upon us to point it out कि जी ये law में ये anti-competitive है, ये anti-competitive है. So it's before something happens, even at the policy stage, we do advise in our advisory capacity, and at times it has been accepted and relied upon by the parties before the courts to get that thing, struck down.
In fact, if I may just add, there should be a national competition policy. I don't think.
Yeah, इस पे भी एक पूरा session हो सकता है.
I think ma'am की term में आपने PTA के साथ एक MOU भी किया था precisely on this
complementary है.
So a lot of regulators can at times come together.
Alhamdulillah, इस last term में हमारे सारे regulators ने, particularly the 5 who pay 3% of the fee and charges, have been very helpful and forthcoming, and they've stopped raising those objections to the jurisdiction.
Did you have any questions, or are we done now?
I have one question for Ms. Rahat, if you may. You mentioned the issues within the CCP. Could you sort of elaborate a little bit on what they are specifically and how you believe that they can be addressed, both from a policy point of view in terms of its domains of responsibility, as well as its internal managerial dynamics and so on? Just as a final.
मैं बहुत broad, because it's a big thing. One, I cannot just sum it up. 2 things that I said. One is political will. If आपकी judiciary, government or CCP are on the same page as to the need for enforcing competition law and prioritizing economic issues, it would be a different thing. I'm not saying that you have to agree with our judgments. Doesn't mean if you're setting aside our judgments, but prioritizing the judicial review is a key factor in determining whether our enforcement was effective or not. That's one. The other is, आपने ट्राइब्यूनल बना दिया. ट्राइब्यूनल प्राइमरीली इसलिए बनाया कि बैकलॉग ऑफ केसेस कम हो जाएं. अब ट्राइब्यूनल बना के आप उसको ही, मतलब हमारे टाइम पे वी वर लकी कि थ्रू आउट ट्राइब्यूनल भी इफेक्टिव रहा. मेरी जिस दिन खत्म हुई है टर्म, उसके नेक्स्ट डे उधर से भी खत्म हो गई. फिर इट हैज बिकम इनइफेक्टिव. एंड इफ यू लुक एट द चार्ट ऑफ ट्राइब्यूनल, हाउ मेनी टाइम्स इट हैड अ फुल बेंच, you'd yourself know what the commitment is. So these are the enforcement side issues. Judicial review, federation को हर केस में जब हमारी हाजिरी होती थी पब्लिक अकाउंट्स कमेटी में, सेनेट की इसमें, तो मैं तो बड़ी वोकली ये बात कहती हूँ कि what bars कि हम अटॉर्नी जनरल के साथ लेजों इफेक्टिव रखें, फेडरेशन भी इसको प्रेस करे. आप सीमेंट का एक I'm not, because you're a cement lawyer, please don't get me wrong, but cement industry impacts 45 industries, कितना वो economy पे उसका impact है. तो 24 hearings, and they've not been able to convince that they should allow to conclude us the inquiry, जहाँ पे हमने preliminary finding दे दी है, कार्टल की प्राइस फिक्सिंग की, कोटा फिक्सिंग की, सारी चीजें on record है. 24 hearing में हमारे कोर्ट को ये बात समझ नहीं आ रही, it's a matter of public interest. We need to raise this. We need to understand why it is so. So, ये बहुत जरूरी है. On the administrative side, I'm not talking about CCP alone, but I feel public sector में, at a higher level, it should be performance based. ये जो हमें एक sense of entitlement हो जाती है ना वहां जाकर के कि हम public servant हैं, हम अपने आप को civil servant समझना शुरू करते हैं कि हम regular हैं, हम भी एक performance pressure आना चाहिए. आपकी salaries बेहतर हैं civil servant से. Why? You perform better. So senior people should be on a contractual thing so that they feel the pressure that they have to perform rather than just tagging along.
Can I just add to this from an academic perspective? ये जो आप बात कह रही थी कि the government, the judiciary, and the authority have to be on the same page. That's
exactly, in prioritization, I qualify.
Exactly. No, I understood that. I think that's exactly the point about adapting laws. कि जब आप उसको लाते हैं, सिर्फ एक मॉडल आप टॉप डाउन भेज ना दें कि बस अब ये लॉ हो गया, सब कबूल कर लें. उसको समझें, उसको अंडरस्टैंड करें और उसको साथ लेके चलें. इंडिया में एक चीज हुई थी कि जब उनका लॉ बना 2002 में, तो वो विदिन डेज चैलेंज हो गया सुप्रीम कोर्ट. उनके सुप्रीम कोर्ट में इस बात पे चैलेंज हुआ कि इन्होंने ये जजेस को अपॉइंट कर रहे हैं कंपटीशन कमीशन में ऑफ इंडिया में, और ये बेसिकली उन्होंने कहा कि ये जुडिशियल फंक्शन परफॉर्म कर रहे हैं, और वो जुडिशियल फंक्शन जो है वो सिर्फ जजेस कर सकते हैं. ये इन्होंने नॉन जजेस को कैसे दे दिया. वो केस कभी डिसाइड नहीं हुआ. government of India went to court, agreed on a compromise and amended the law. What that case really achieved is called the Brahm Dutt case, which I talk about a lot. What that case really achieved is कि government का point of view, judiciary का point of view और authority जो एक थोड़ी सी उन्होंने बना दी थी, उनको समझ आ गई कि हमने साथ मिलके चलना। हमारे पास भी एक केस आया सुप्रीम कोर्ट में, मौलवी अनवारुल हक का केस था 2009 में, जब जुलाई में उन्होंने, उसमें क्या था, ब्लैंकेट उन्होंने सारी ऑर्डिनेंसेस को कर दिया, चार महीने के अंदर इनको वैलिडेट करो वरना हम इनको लॉ नहीं समझते। नो एनालिसिस कि भी क्या होने जा रहा है, क्वाज़ी जुडिशियल, आप कभी मेरिट पे बात ही नहीं हुई। सो आई थिंक ये सेम पेज वाली बात बहुत इंपॉर्टेंट है, एंड दैट्स प्रिसाइसली व्हाट इज अचीव्ड through deliberation and bringing all stakeholders, quote unquote, on the same page. Second, I just want to completely agree कि tribunal बनाया है तो उसको किसी आपने authority बनाई है उसको populate करें. I deal with this in the book extensively कि आपने अपनी composition complete करनी है. अगर आप authority को mandate दे देंगे, structure भी दे देंगे, compose ही नहीं करेंगे तो क्या फायदा? Composition से फिर दूसरी तीसरी बात का भी जवाब आता है. She thinks that contractual thing is very important. I think उसी से जुड़ी हुई बात है कि गवर्नमेंट के एक्सक्लूसिव कंट्रोल से अपॉइंटमेंट्स बनकर कर। अगेन इंडिया में जब ब्राह्म दत्त की बारी जब डिस्कशन हुई तो उसमें एक अमेंडमेंट बहुत बड़ी आई। आई एम नॉट सेइंग हाउ इफेक्टिव दैट अमेंडमेंट इज, बट ऑन पेपर इट वाज अ बेटर अमेंडमेंट, व्हिच इज कि ऑल अपॉइंटमेंट विल बी मेड बाय एन इंडिपेंडेंट सिलेक्शन कमिटी।
उसमें जुडिशरी इन्वॉल्व है।
हाँ, जिसमें जुडिशरी इन्वॉल्व थी, सुप्रीम कोर्ट का चीफ जस्टिस बैठता है उसको। हमारे यहाँ आई मीन आई एम नॉट अगेन सेइंग जस्टिस इफ्तिखार चौधरी डिड एवरीथिंग राइट, बट ही टॉक्ड अबाउट एन इंडिपेंडेंट कमिशन फॉर अपॉइंटिंग रेगुलेटर्स. Nobody got appointed for 2 years. So we have real problems, but I hope that with scholarly work and with these discussions, we are able to share these problems and ultimately to show that, there are ways forward, but we need to understand the problems first before we can go.
बिल्कुल, I would not disagree with you कि आप इसको निकालें उससे, लेकिन उन्होंने एक competitive process तो दे दिया, सारा framework भी दे दिया. अब वो process कितना fairly implemented, we see this is like having a good law and who's enforcing it. So just having a system is not enough.
Thank you. And with that, I'd like to bring this to an end. We are about 2 hours in. Thank you so much, Dr. Darr and Ms. Rahat. Appreciate your time, and thank you all for joining us. And if you'd like to stick around and have a chat, feel free to do that as well. Thank you. Appreciate it.